Good evening and welcome to this session of the live virtual coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. This session, we are going to take up the next topic in your syllabus on directors, which is appointment remuneration of managerial personnel, right? Before I start, let me say hello to people who are there. I see Soham Bakre. Good evening, sir. And maybe others would join in quickly. No problem. And those of you who are there, hi and welcome. Do keep sending your queries. Right. Now, today's topic is quite interesting. Okay. We are going to talk about managerial personnel, meaning people who are involved in the management of the affairs of the company. I don't have to tell you at the final level of CA about the dichotomy. Dichotomy means division, separation of management and ownership of companies. We already saw that. And we also saw that the board of directors manage the affairs of a company, whereas the shareholders are the owners. Now, within the board, there are some distinctions in terms of who manages on a day-to-day basis and who is only sitting on the board and advising the management. So today's topic, we'll be talking about how these people are appointed: managing director, manager, whole-time directors, part-time director. We already saw independent directors, etc., etc. While we did that, I did talk about executive directors and non-executive directors. And I made the distinction between executive directors and non-executive directors. Executive directors are those who are engaged in the day-to-day management. Day-to-day means hands-on. They will be available. People will be reporting to them. The employees will be reporting to them, and they will be taking day-to-day decisions. Not at the operational level, ideally at the strategic level, but sometimes even at the operational level. Even on a day-to-day basis, they will take decisions. Hands-on, which means they are entitled to some kind of remuneration. Please understand this. Non-executive directors are almost like employees, high-paid employees, right? Including, for example, if some of you become CFOs, members of all the three institute, flying carrier, okay, high flyer, you move on and on and go up, right up to the dizzying heights, you will become a member of the board. You will be invited by the board of directors. You will automatically become CFO, maybe automatically a member director of the board. Nothing wrong in that. But you would then become an executive director because you are engaged in the day-to-day. You have to go in the morning, 9:30 a.m. sharp, bell will ring. You have to be there and returning. Okay, that is God's own guess. When you will come back. Reporting, yes, 9:30 sharp, you will be there. Returning back, God only knows. Whatever it is, you're going to be engaged on a day-to-day basis with these companies. Therefore, you would also come under the executive category, including the managing director and whole-time directors, etc., etc. Obviously, these people would be entitled to some kind of a remuneration. By the same token, part-time directors or non-executive directors, including the independent director. See, the independent director can be paid remuneration as a director, which is what we are going to see now. The type of remuneration that you can pay for non-whole-time directors, whole-time director, non-whole-time director. Non-whole-time director also can part-time director. Executive director, whole-time director. Okay, so these are easy to understand. Executive, whole-time. Non-executive, part-time, also non-whole-time. Okay, non-whole-time is part-time. It's up to you to use the words. These are only sub. They are only words you can use, but the meaning is important. Okay, arth important. What does this mean? What does that mean? Then you use anything you want. Generally, they are synonymous. In fact, the current Companies Act doesn't define one or two of these, and we have to just guesswork. I'll explain to you as we go. And moving on. A very important definition: managing director. This is a very important definition because managing director is a very important person in a company. In fact, you could say virtually all said and done, this is the guy who runs the company. For example, Mr. Dhirubhai Ambani was the managing director of Reliance Industries, like that. So when you deal with this type of a situation, the managing director becomes very, very important. And the definition of who is a managing director is given into subsection 54. A director who, by virtue of the articles of a company or an agreement with the company or a resolution passed in its general meeting or by its board of directors. So the articles can provide for MD appointment, or there could be an agreement between the managing director and the company, or a resolution passed in its general meeting, or by the board of directors. So in those cases, a person, any director who is by one of these means, any one of these means, for example, a company may managing director and say, so-and-so will be the managing director of the company and his powers will be so-and-so. No problem. Or there could be an agreement between that person and the company. Or the members may pass a resolution in the general meeting appointing him. Or the board may pass a resolution appointing him. See, managing director can be appointed by the board. There is no need for a resolution unless you are exceeding the remuneration issues. So long as the remuneration you are paying within the limits, we are going to say everything fine, he is always eligible, he is not disqualified, blah, then the board can as well appoint the managing director and go on with life. They don't have to, have shareholders appointment. It's as simple as that. But the problem is most companies, something or the other will be a problem. One condition will not be met, in which case you have no other option but to go to the members and get their approval, right? So, any director who is entrusted with substantial powers of management of the affairs of the company, substantial powers of management of the affairs of the company. That wording is very important. The word substantial is very, very important. Okay. Gurkha does not have substantial powers of management. He only has gate management powers. Whereas MD has power to hire, fire, buying assets, selling assets. Subjectly to those, the next topic when we see powers of directors, you will see a lot of restrictions on the powers of the managing director, but very, very reasonable restrictions, which are meant mostly financial restrictions. Otherwise, on policy issues, on employee management issues, on operational issues, the managing director has a lot of power, substantial powers of the affair. If at all there is any restriction on the MD, it will be only on financial matters, which we will be seeing in the next chapter, right? So, any director who is entrusted by any of these means with substantial powers of management of the affairs of the company and includes a person and includes a director occupying the position of managing director by whatever name called. William Shakespeare, in his famous play, I'm sure you are aware of the play, Romeo and Juliet. There's a famous dialogue, rose by any other name smell as sweet. Therefore, they say a managing director by any other name would still be a managing director. You call him chief executive officer, you call him chief enabling officer, you call him anything, yeah. Whatever you call him, it doesn't matter. Does he have substantial powers of management? Tick, yes, then he is MD. So, the name is not important. The title is not important. You might give all sorts of... In fact, in HR, the new theory is we should become a servant manager. The chief executive servant. He doesn't know. Whatever you say, I'm a chief servant. Whatever you say, okay, if you have substantial powers of management, you are MD. The minute you become MD, you know what will happen? The stringent provisions of the law will apply to that person. The law, in fact, even if there is a board of directors, if there is an MD, the MD is primarily responsible for the compliance with laws. Later on, when you go to laws, maybe you study company secretary or whatever, you will come across industrial laws, you will come across all sorts of laws. Everywhere you will find if there is no occupier for a factory, straight away managing director. Competition Act. Anywhere if there is some penalty, punishment, if that is not delegated to somebody, then directly it will go only to the MD. Straight away, liability will be with the MD. Many other laws, other than company law. Company law, you will find most often it is a company and every officer in default, which includes our friend, the managing director also. But in other laws, especially criminal laws, you'll find if a company commits an offense, the MD is responsible because he is seen as the brain driving the company. Actually, there was a company, a .com company called Bazi.com. Maybe you know it or not. Bazi, like Orkut, not Orkut, like Oyo and Oyo. What is that? What is it? It's basically a bartering site, Bazi.com, where you simply went, put up something there, somebody wanted to buy it, they bought. This fellow only got commission out of the deal and he was more like an aggregator. Those days, Bazi.com. Today, you can do that directly on Amazon itself, I think. I don't know. Seriously, I'm not aware. Bazi.com. Now, Bazi.com, what happened? Unfortunately, one person, underage person, there was a guy who put up some certain types of pornographic material on Bazi for sale. He put it up on Bazi.com for sale. And it came up and somebody complained. And you know what happened? The guy who put it up was definitely liable. But the law simply said who facilitated it, Bazi.com. Okay, so they are liable under the cyber law. Agreed. And who was the guy who was behind the whole thing? Who is the man? MD Bazi.com. And that was the time when they were testing the cyber law's muzzle. And they wanted to really prove that cyber law is powerful. So they arrested this guy, MD of Bazi.com. They arrested him and took him to jail. 2 days. He will come out on bail. But the point is, MD is, which is why a good managing director will always have advisors with him. He'll always keep intelligent people under him so that compliance is not an issue. Right. In fact, most of my clients who are managing directors, I sensitize them to this and tell them, hey, before you take any decision, before you talk to anybody, talk to me first. Tell me what you're planning to do. I will tell you what the law is and how it will apply. Taxation, finance, company law, etc. Then you go to somebody, even I will try to guide you on labor law. Otherwise, we'll go to a guy who's extremely good at labor law, GST. We'll get opinions and then you do this, which is always a good idea, rather than do something and then get into trouble. So with this explanation, I hope I have helped you to understand the type of responsibility which a managing director has, which is very, very important. So, what I would now you might ask me, who is a manager? See, this definition of 2 subsection 53 needs to be understood from a very long-term old perspective. See, you should know that the 1956 law is the precursor. Before this, you had the 1956 law. Even in the 56 law, you had a manager. You had a guy called manager. The manager had an important role to play in a company, right? Now, I'm getting one feedback that there is some disturbance from Ms. Kodali. I will do one small thing to correct that if possible. I will do that and then I will just restart. Give me 1 minute. I will try to change my connection, right? I will try to change my connection. Give me 1 minute to do this. Then maybe it will become better. Because sometimes connections are a big problem. I'll do this so that you won't have any such complaints, etc., etc. Right. Let me see if I can quickly change it over. Okay. I'm sure there should not be any more problem. Let us hope that Ms. Kodali's problem is solved. Anyway, see, as I always keep telling you, this part of the program, not my thing, still, this connectivity is a big problem. And all that. I always, whenever I have this connectivity issues and all, I'm reminded of the famous teacher, Chanakya. Actually, Chanakya was Takshila. Takshila is in Afghanistan, current Afghanistan. He was a teacher in Takshila. He was by no means a politician, a statesman. He need not have written Arthashastra. He was simply sitting in Takshila teaching students philosophy and Sanskrit and etc. etc. Political theory and all. He was a pure academician, not exactly like me, but he was also a teacher. Suddenly, one fine morning, his students came late, and some of them were a little worried and all. So this guy asked, what happened? So So they said the Greeks are invading from Persia. We are getting the Greeks coming in. And here the Nandas are giving us disturbance. And there's a lot of problem. We are unable to study. Therefore, that is when Chanakya comes all the way down to Patna, Pataliputra, and he wants to meet Dhananda and tell him, prepare yourself for the Greeks, chase them out of the country. But the Dhananda and the other Nandas, no, they are absolutely irritate him and insult him. That's when he, sort of makes the famous vow. You know what? The whole story that is called Raksha Samudra, Chanakya fights the whole thing. He encourages Chandragupta, mentors him, brings him up. Chandragupta defeats the Nandas, then he defeats Alexander himself, and then he takes over the whole of India. The Mauryan Empire is born. Then Chanakya goes back to Takshila and says, now that peace has come back to this country, I will go back to teach. Just why I thought I'll tell you this. It's a very interesting, very inspiring story for a teacher. Another teacher did the same thing. The famous Abdul Kalam, after he became president, then he retired, then he went back to teaching. He became a teacher again, I think. So the point is, this type of disturbances, when they come, they disturb the whole thing. That's when better to stop the disturbance, again come back to the subject. Coming back to the subject, the word manager is a stupid word. You see, manager is a cheap word. Hey, who wants to be manager? Suppose the company appoints you and says, we will make you manager. Will you be happy, boss? Minimum, you'll say, I want deputy manager. I want some higher level, right, than manager. Something big, general manager, whatever. So, who will want to become manager? But the problem was, many companies wanted to defeat the provision. See, look at the definition of managing director. What is the important thing? Substantial powers of management. More important, to be a managing director, a fellow should be a director. A director, who by virtue? So some people had this intelligent idea long ago in 1960s. They said, you are making managing director liable, is remuneration, you're doing all sorts of nonsense. Go ahead and do it. Our company does not have a managing director. In fact, we don't have, all the directors are non-executive directors. We have a manager. He's a manager. He's not a director. He's a manager. No, how will your law apply to me? So they started doing this nonsense. Immediately, Parliament amended the law long ago. This is not something new. 2013, it is maybe it is law also. Manager is defined as an individual who subject to the superintendence and control and direction of the board of directors, has the management of the whole or substantially the whole of the affairs of a company. That is, this is a guy who is like a managing director but not a director. He operates subject to the superintendence and control and direction of the board. He has the management of the whole or substantially the whole of the affairs of the company. It includes a director or any other person occupying the position of a manager by whatever name called. It includes a director. Okay, suppose you call a director a manager, even that will be covered. By whatever name called. You call him anything, as I said, CEO, CLO, CXO, whatever nonsense you say, if he is having the management of the whole or substantial whole of the affairs of a company, straight away he becomes manager. Simple. From now on, every rule that applies to MD applies to manager also. Remember, restriction on remuneration, liabilities, disqualification, everything. Whatever applies to MD will apply to manager also. And to a great extent, it will apply to WTD also. With one or two exceptions, the rules that we are going to see will apply uniformly to managing director, manager, whole-time director. Managing director, manager, whole-time director. Right? Schedule 5 also, managing director, manager, whole-time director. We'll check it out. Okay, one small point. If you are all there and if you are listening and if there is no problem with the connectivity, I'm going to ask you a very simple question. Can a company have more than one MD? Similarly, can a company have more than one manager? Can a company have more than one MD? Can a company have more than one manager? This is the question. I will not wait for your answers because time lag is there. But keep it going, and when you get the answer, you put it up in the keypad. Yes, no. MD, yes. Can a company have more than one managing director? MD, yes or no. Manager, yes or no. Just you put MD, then your answer. Manager, your answer. Even if you don't want to type too much, then put MD, your answer. MGR, the famous Chief Minister of Tamil Nadu, but we'll call him. So Darasha ji, don't put no, yes. I want MD, yeah. See, then I'll know which one you're answering. Otherwise, we'll get confused, right? So those of you who put no, yes, and all, just add 2 letters, MD, or 3 letters, MGR, manager. Okay. Waiting for your answer again. Re-put it, re-send it. Okay, I don't want to double guess and then we'll get into so, just take your fingers there. One more typing, please. My friend Soham Bakre says cannot have more than one MD, but can more than one manager. Wow. MD no manager, yes. Wow. That is why I asked this question. K. Gayatri also says MD no manager, yes. Dara Shah, little waiting for your answer, madam. See, friends, look at the 2 definitions. Manager, no. First time I'm getting a right answer from Jishnu. MD says no. Actually, the definitions contain the answer. That's why I'm asking this question at this stage itself. Only one MD? No. Okay, let us see. See, look at manager definition. What does it say? He has the management of the whole or substantially the whole of the affairs of a company. Right. I have an apple. I tell you, eat the whole apple. Can 2 people eat the whole apple? Or substantially the whole apple? Can 2 people eat? No, not possible. Because suppose you give a small piece to somebody, you are not having substantially. And he is also not having substantial, the whole. Think about it. The minute you give him a small piece, you are not having the whole. So you are not manager. Right? He is also not having the whole. Right? So you cannot have, you are not having substantially the whole also. Substantially the whole means, 98. Okay. So company cannot have more than one manager. But MD, there is no such restriction. It simply says he is the director with substantial powers of management. There can be 2 people with substantial powers of management. Whereas the wording of the manager definition is the whole or substantially the whole. Just keep it in mind, especially when we come to remuneration. Remember, company can have more than one MD, but cannot have more than one manager. So that is how the answer is. So many of you got it wrong. Maybe your logic was different, but the logic we are going by is the whole or substantially the whole of the affairs of the company. Only one person can have the management of the whole. Therefore, only one manager. MD, no such restriction. Therefore, you can have MD, you can have JMD and all. Which is why they say for all managing director, for all managerial person put together, whole-time directors put together, they say 10%. Later on when you come to remuneration. Company can have more than one MD. JMD can be there. In fact, many of my client companies, the father will be there, 2 sons. I told you that he will become chairman emeritus, and the 2 sons one will become MD, the other one will become JMD, joint managing director. So nothing wrong. But manager can't have more than one, right? So what is substantial powers of management? The following powers shall not be deemed to be included within the ambit of substantial powers of management. For example, the power to affix the common seal of the company to any document, draw or endorse any account of the company, draw a worshipful instrument, sign any share certificate, direct registration of transfer of income. These are not substantial powers of management. This is because the above powers are merely administrative acts of a routine nature, right? And may be exercised in a senior level employee, like a company secretary or even the CFO. Definitely, see, company secretary will have control of it. He will affix it. Company secretary can definitely sign certificate of care. Any director can do any of these things. Okay, even CFO can do signing checks and all that will be delegated to CFO. In fact, these are all very important powers, my dear friends. As you grow, as you become members and join large companies, you know, when you initially join, they won't give you check signing power. But certain positions, you know, you will have check signing power and all. Which is why, for example, 7-year experience chartered accountant, if he is quitting the company, he cannot give 1 day's notice or 30 days notice. Minimum 2 months to 3 months also. Minimum. Because they have to locate a new CFO. He has to come, take over. You have to hand over the charge. He will even go through it himself. Then you will have to give replies to the board. And then once he says everything is fine, then only the board will relieve you. Okay? Sort of. So that is why, these are all, as you grow higher and higher in your career, remember these things that I told you. Okay, check sign is a very important power. So definitely the checkbook will have to be handed over. You'll have to account for every check, or else if you, okay, at your level, you may not. Your team should be able to tell him. Then he will take charge. Maybe you will be at home. You won't be in the office, but you would not be relieved till then. You will be taking your leave, enjoying, but still you will be worried. Hey, everything should go fine. And you would have told the other company, I will join on the 1st of next month. And still this is going on. So you will have to be relieved and all. That's a little bit of a pain, but that's okay. Sometimes I tell all stories and real life examples, my dear friends, to help you understand that this is not a dry subject in print and ink on a white paper. This is your life, my life. This law is our life. We are going to live this law. You and I'm living this law already, and you will have to live this law as a CFO, as a practicing CA. This law will be with you, and it will be guiding you, and it will be directing you, and it will also be sometimes threatening you. Therefore, understand from that perspective, rather than dry mug up but keep the questions coming. I'm not getting many complicated questions. Anyway, don't worry. This topic is capable of raising questions. Not because it is not a complicated topic, but these our great draftsmen sitting in Parliament and Ministry of Corporate Affairs have made it complicated. You'll be seeing how they have made it complicated by confusing, by running around the mulberry bush. By lack of clarity, they have confused it. They could have easily, see, the old law was excellent. Schedule that. The only problem the old law was, there was a lot of control, and the central government played a very vital role in appointment of managerial personnel. They wanted to remove that. They wanted to give companies more freedom to appoint managerial personnel. They wanted to give more power to the selection committee, remuneration committee, etc. That can be accomplished. That could have been easily accomplished in the old law itself. All it needed was a few small amendments. Instead, they have tried to reinvent the wheel, and in that process, confuse themselves. If at all the law is complicated or confusing in this chapter, but it's very interesting, no doubt, but it's going to be very, please, not me. Okay, thank the gentleman who drafted this law sitting in Ministry of Corporate Affairs. When we come there, we will find out what they have done. Even then, what I'm going to do, I will take you through the mulberry bush. Don't worry. If they were running around it now, I will take you through it. I will show you where the issues are. We will resolve it, and we will come out of the maze, and I will take you out of the maze. Don't worry about that. Okay? Once you understand the principles, you would have understood. In spite of the bad language that they've used, bad means not vulgar, but ungrammatical words, ungrammatical language, still the meaning is clear. The intentions are honorable. Their ability is not there. The drafting ability is not there. The intentions are honorable. Okay, but the ability to draft was not there. Therefore, they made asses of themselves. But still, I have been taught by my guru when teaching law, never to reduce the law to a futility, but rather to give life and soul to the enactment, which is what we will do. Some more definitions before we go on to the provisions. Whole-time director includes a director in the whole-time employment of the company. That's all. It is defined. Director includes a director in the whole-time employment. For example, CFO, whole-time director. Anybody, not necessarily. It could be anybody. Even anybody could be a whole-time director. Okay, so long as he should be working whole-time, which means what? Morning to evening, he should be here. He should not be employed anywhere else. So a person can be whole-time director only in one company. Got it? A person can be whole-time director only in one company. I hope I'm communicating this. But he can be a sitting non-executive director in other companies. But executive director only in one company. He can't be executive director in two companies. But non-executive director sitting on the board, no problem. He can. Okay. Don't confuse. That's where you have to be careful. Part-time director doesn't mean like part-time employment. That's why I prefer to use the word non-executive director. He can be a non-executive director anywhere. But he can be a whole-time director in only one company. In fact, earlier, before this independent director became very stringent, you know what people used to do? A guy will be an employee director in one company. They will make him non-executive director in another company and make him independent director there, which is absurd. Today, he cannot be, because he is employed here. Out. He is not independent there. You remember, go back to the definition, you will see that. either in this company or in its subsidiary or in its associate company or in the holding company. Nowhere he should be employed. If he is employed anywhere, he is out. Okay. Or if he's a key managerial person, he is out. We saw that. Now, no company shall appoint or employ at the same time an MD and a manager. Means you can have more than one MD. You cannot have more than one manager. But you can have two MDs. But you can have only one manager. And you cannot have MD and manager at the same time. Try to remember this as sort of, don't forget it. If you see somewhere MD and manager, hey, no, not possible. Okay. You can have MD and whole-time director. You can have one MD and three whole-time directors. You can have two MDs, any number of whole-time directors. Because later on, you're going to see the ceiling limit. Saying, hey, one MD means 5%. Yeah. More than one MD or WTD, boss, you pay anything to anybody. Total limit 10%, straight, take it. So long as one guy should not get more than 5%. Take it. So that will be meaningful that time. Now, for the sake of convenience, we won't say managing director. I would rather say MD, whole-time director, WTD, and manager is M. When I say M, it means manager, not James Bond's boss. You know, James Bond in the famous Ian Fleming novel has a boss who is M. Okay, and he is not 7, and his boss is M. Okay, M is manager. Okay, maybe that is the M there also. We do not know. Maybe that's what it means. M is manager. Okay, and collectively we call them MD, WTD, and M. So for sake of quick speaking, I will say MD, WTD, M, and don't get worried. That's what this means. The word part-time director is not defined anywhere in that. Take my word for it. If you don't believe me, search section 2. Go to the barrack, put search on the online, put search part-time, or just put part. You won't find a part-time definition. That's not a problem, because there is a slight indication in the second proviso, 197.1, refers to directors who are neither managing directors nor whole-time directors. Somebody who is neither a managing director nor. So you ask, do you have substantial powers of management? Are you in full-time employment with the company? Yes. Do you have substantial powers of management? MD. No, sir, I don't have substantial powers of management, but I'm in full-time employment, whole-time director. Got it? Call the director, ask him, are you in full-time employment with the company? Yes. Are you having substantial powers of management? Yeah. Then you are a MD. No, I don't have substantial powers of management. Then you are a whole-time director. Third fellow says, hey, I'm not in full-time employment, boss. I only sit in the board. Do you have substantial powers? No, I don't have. Then you are a part-time director, non-executive director, whatever. Got it? That is how we'll have to distinguish and bring out part-time directors. In a way, this is a classic negative definition. Are you able to understand? A part-time director is one who is not a managing director or a full-time director. Because we've defined those already, right? Companies that does that a lot. They will define your word negatively, and whatever is negated, they will define correctly. Okay, so that once you understand the negative part, automatically what is not will become easy. Correct? Tenure means term of office. Tenure, T-E-N-U-R-E. Hey, if you want to use these lectures to improve your vocabulary, go ahead and do that. Right? Whenever I use a word that I feel somebody may not understand, I would give a definition also, or I will explain it also. So try to, when you come across a word that I'm using, which you feel is new, because sometimes I listen to somebody, suddenly he uses a word, I love it, I make a note of it, I look it up, and then I start using that word in my language when I speak. Automatically it becomes part of my vocabulary. Okay, simple and easy method of improving your vocabulary in English. Vocabulary means number of words that you know in a language, the number of words that you know. My problem is in Hindi, my vocabulary is very less. I don't know that many Hindi words, and my grammar is even worse. Okay, so that's possibly why I'm not able to speak Hindi very fluently. Though I'm trying to learn continually, I try to learn. I try to pick up new words in Hindi, new usages. Try to use it, but then let's see. Okay, so I am learning Hindi now. You all should learn English. Okay, good. So term of office of MD, WTD, or M shall not exceed 5 years. So, like auditor's appointment 5 years, like that, MD, WTD, M shall not exceed 5 years. Reappointment shall not be made earlier than 1 year before the expiry of his term. Means you are appointing him for 5 years now. At the end of the 3rd year, you cannot appoint him for another 5 years. You have to wait for 1 year before the expiry. That is during the 4th year. That is the beginning of the 4th year only, you can reappoint him. So 4 years he will hold office. When he is going through his 5th year, during the pendency or during the continuation of his 5th year, you can reappoint him for another 5 years. Somewhere. Because you can't wait till the last day of the 5th year, boss, and then appoint him, because 3-4 days he won't be. So you can sort of nearing the. Usually what we will do in the 4th year ka AGM, at that time, we will take up his reappointment for another 5 years. Beginning from the end of the 5th year. Okay, so that he'll have that 1 year and then he will continue. Disqualifications. Friends, before we qualification, I want to explain something to you. Try to wrap your minds around this. You already saw the disqualifications qua or as or for a director. So for a director, we saw disqualifications. You remember, na? 166. We saw 166, 1, 2, so many disqualifications. They are actually easy compared to the MD disqualification. The of directors aren't that tough. Whereas for MD, you will find further disqualifications are there. So I always like to compare this with one example I will give. A metaphor, not a metaphor, an example, a simile. Like, I don't know if you, in those days, there used to be circus where there will be a very, very powerful show at the end where a tiger will jump through a hoops. This man will have a huge iron hoop ring. And, he will be holding it, the ringmaster will be holding it, and the tiger will jump through the hoop. So, the disqualifications of a director are a pretty big hoop, pretty big. See, the first initial stage, he will not do much. He will show a pretty big circle, and the tiger will be able to easily get through. Then, he will hold a slightly smaller hoop. So, it's going to be a little tough. Okay, little tough. The tiger will somehow squeeze through it and go. We will also give a sigh of relief. Finally, he will hold up a very exact size. Almost. Tiger can just squeeze through. If it jumps quickly and holds his leg correctly, it can go through. Otherwise, it will get. Not only that, that final circle, will have not only be smaller, it will also have fire. And that is a test of fire. You have trained the tiger so well, the tiger will come quickly running, pounce, jump through and go. It won't get singed by the fire. So, the big hoop is the director disqualification we have seen. Normally, any tiger can get through that. This is a slightly smaller hoop he has to go through. Any person, if you want to get appointed as MD of any company, you have to go through, you will have to satisfy these conditions. Later on, we will find Schedule 5. In Schedule 5, we will find further disqualifications or similar disqualifications. But that is the smallest hoop and fire hoop. It will be very difficult to get through that hoop. Okay? If you go through that, what I'm saying. If possible, compare it with 166 later. You will find becoming director fairly easy. Not anybody can become. MD, further disqualifications. This is a slightly smaller hoop now. The person should not be below the age of 21 years. See, earlier we said, any person who is a minor cannot be a director. Okay, obviously, because he doesn't have the ability to enter into a contract, any contract with him is void, right? So generally, minor is not allowed. Chalo, no problem. Minor is only 18. 18 plus. Once he becomes 18, you can become director. Na? Sorry, for becoming MD, he should be above 21, not be below the age of 21 years. 21 is seen as some sort of a magic number. I do not know. Even in certain other associations, if you want to become a member, you should have completed 21 years of age. One wonders what 21 is. Maybe some British significance might be there. Maybe 21 was the age when a lord or a son of a earl or a lord could inherit his property. Maybe the British law feels or felt that 21 is the age when the person will become truly mature. And 18, I don't know. In India, 18 is the age of majority. But here they are saying if a person should be MD, wants to become MD, 21 years. Now you understand, big hoop, anybody less than 21 also can become director. But if you want to become MD, then you should have completed 21 years. They feel 21, right? But again, I humbly beg to differ. Okay, I'm pretty senior, and I humbly beg to differ that age. There are so many people at the age of 18 and 19, they are highly intelligent. I have a lot of my article clerks, my mentees, people who come to me for advice and all. Youngsters come to me, 18, 19, 20, pretty clear. Not just in terms of intelligence or brain, in terms of common sense and clarity. In fact, on some occasions when I have picked up a couple of thoughts from them, okay, I have learned from them, but still they feel 21 is the ripe old age when you can. Similarly, they say the man should not have attained the age of 70 years. Oh, Buddha ho gaya, 70, go home, old man. Sorry, that's not fair. I'm 57. Okay, according to me, there should not be any retirement age. My father, 89-year-old, practicing chartered accountant, still sitting, and he's still practicing, still aware of the law. 89, okay, right? Give or take 6 months, 89. So, chalo, anyway, but they feel 70 is a little old. Chalo. Even then, they're giving the small loophole. They're saying a person above 70 years may be appointed by passing special resolution. They're saying, hey, go back to your own members. If the members are okay, you appoint him, provided they pass a special resolution. If special resolution, but simple majority is obtained. There's a divided opinion. Okay, but then still majority people, not special majority people feel an ordinary resolution is passed wherein they all agree, okay, let him go on another 2 years, another 5 years, whatever. Okay, then still you can appoint him, but you can do it only with the approval of central government in appropriate cases. Okay, is the point. Of course, most of you here being less than 40 may be of the opinion that, hey, 70 is too old, man. What we forget, 70 plus brings with them not knowledge. Okay, knowledge, you can acquire it by studying, etc. But experience is something you can get only by living. And the longer they've lived, the greater their experience. That experience should be available to the company is the bigger logic. Therefore, the law does not put a prohibition. They say it is like this. WTD definition for group company. If your director is WTD in holding company, then he can't be WTD in subsidiary, associate, or JV. Good question. WTD, I don't really understand. Yeah, see, the point is not that. The point is a director in the whole time employment. So if you are a WTD in holding company, then how can he be again WTD in subsidiary? The word, madam, you look up the word in the dictionary, whole time. Okay, then you will understand why he can't be WTD in both holding and subsidiary or associate or JV, whatever. Think about it. The problem is in the English meaning of the words whole time. Okay, so hope you have understood, Daraji. He cannot be. That's what I feel. He can be part-time director. See, usually what happens now, man will be whole-time director in the holding company. He'll be sitting in the board of directors as a non-executive. No problem. But how can he be whole-time in both? It's like telling I'll be employed with you will be employed with A Limited full-time, B Limited also full-time. How is it possible? If it is possible, you tell me. You understand? Logical. Okay. You will have to now explain to me, how is it possible for a person to be employed full-time? See, if I use the word full-time, maybe does it help you to understand the word whole-time better? Full-time. Full-time, how can he be employed in two companies? Not possible, enough. Even if you are employed part-time in one company, you will be part-time, not full-time here, right? Because the word whole-time is used very, very strongly. Your entire attention should be given only here. But you can be a non-executive director in the board of the other company, subsidiaries, which is how usually it will be. They'll be sitting full-time here. Non-executive, they'll be sitting there. Obviously, because we need this guy's inputs there. Yeah. See, he's sitting there. He's the VP Finance, whole-time director there, financial director there. Obviously, on the subsidiary, we need him now. So instead of we make him non-executive here, there'll be a whole-time director there for the subsidiary. This fellow will attend as a non-executive. He'll give his views as a whole-time holding. So the purpose will be accomplished, even if he's non-executive director. He need not be whole-time director in both. Okay. kindly understand the meaning of the word whole-time director. Okay. This is very, very... The person should not be an undischarged insolvent or at any time been adjudged as an insolvent. See, for a director, once he is discharged, he can become a director. Got the point? Once he is discharged, once his debts have been paid, partly, fully, whatever, the court says discharged, okay, then he is now eligible to be appointed as a director, sirf director. But to become MD, should never have been adjudged as an insolvent in his life. Never, at any time, been adjudged as insolvent. Which is why, if somebody wants to be MD, etc., they should be very, very careful in their own financial affairs. They should not borrow in such a way that they will become insolvent. So, obviously, now see, you are asking this man to manage the affairs of the company, boss. He couldn't handle his own affairs. Fellow became insolvent. How can he be MD? Got it? See, this disqualification applied to MD, LTD, and M. Please, that's why I told you again and again, I may not be able to repeat it. So, all these things apply to all three of them, right? When I may use the word MD because of convenience. But whenever I say, you always look at the top, MD, WTD, MM, all of them. Okay. WTD also, if you want to become whole-time director, you should not be an undischarged insolvent or a adjudged as an insolvent. Okay. You should not suspend the payment to your creditors. Suspended payment to his creditors or at any time made a composition with them. Means instead of, see, the creditors are threatening for payment. You know that at stage if they come, they go for insolvency, you will be declared insolvent. So what you do, you call them for a meeting and say, hey, I'm going to become insolvent. If you guys keep on doing nonsense, I will further borrow. I will create mess for you and run away. Otherwise, listen to me. I got this property worth so much. I owe you all guys. I cannot pay full, but I will pay part. Take it, close it, confirm that everything is paid. Let me go. That is called making composition. Or stop making payment to creditors, suspension. Then call them for a meeting and then make composition with them. Compounding it. Paying lesser amount instead of the full amount. No, even the creditors will agree because intelligent creditor will agree because he will think if I go for insolvency, it will take time. By the time what I get may be less than what this guy is willing to pay. Better make a condition and better make them pay. So he will agree. They will agree. They will take the money. But if a person has done this, obviously he is not an insolvent. He has not been adjudged. But even if he is suspended, etc., it amounts to. In fact, those creditors will insist that this matter should go through court. The whole matter and the court will treat it as an out of court settlement, and then only it will come. It will be recorded. It will be recorded, and it will be an out of court settlement between the. See, what will happen is the creditors will even make a petition for insolvency. While the petition is going on, before adjudgment as insolvent, this fellow will call them and say, "Hey, take this and go out of court." The lawyers will talk and finish and go. So then they will in the court will close the file. So he will not be adjudged as an insolvent, but still he has suspended payment and made composition. Then he is not liable, he is not eligible, he cannot be appointed as MD, WTD or M. Now, at any time being convicted by a court of an offense and sentenced for a period of more than 6 months. This is the words in caps are what is present in the section. Okay, are what is present in the section 96. But I have supplied the words in lowercase. I have supplied because unless I supply it, the sentence has no meaning. The sentence has no meaning. Sorry to say, this is what I said. In their eagerness, they will make all mistakes. At any time being convicted by a court, no problem. Similarly, we have seen for director also. Convicted by a court for an offense whether involving moral or not, and sentenced in respect thereof to imprisonment. You got it? Here the word to imprisonment has unfortunately been forgotten or eaten. Maybe the guy who drafted this was a little hungry. Instead of his usual samosa or kachori, this fellow eat the to imprisonment and sent it to the printer. This went to Parliament, right trially got passed and came out. Okay. Anyway, but unfortunately, I am the teacher of law. So obviously, what other sentence can be there? You can all ask me, sir, can you say 2 imprisonment? It is not there in the act. I totally agree with you. I'm only helping you. If you think it's wrong, what sentence then? And sentence for what? For 6 months. What? Standing on the bench, standing outside the classroom. What? See, think about it. That is why sometimes, I feel very upset when I teach this law, the way it has been made a mess. Okay. Anyway, but the point is this. If he has been convicted by a court of an offense and sentenced to imprisonment for more than 6 months, no problem. If he has been sentenced to imprisonment for a period of more than 6 months, only then. Less than 6 months, he can be appointed as MD. Always remember. But later on in Schedule 5, you will see even more stringent conditions are there. That's why I said, this is slightly smaller hoop. Still not very small. Okay. People can wriggle through this. Okay. Can the following be appointed as MD, WD, or M in any company? I've given you A, B, C, D. Just give me A, B, C, D. Yes, no, whatever you say. Dr. Robert has a PhD from USA in genetic science. Wow. I'm damn impressed. Anybody would like to quickly react to these questions? Sometimes I give these questions more for me to be sure that, I got, you guys are all, and ladies are all listening to what I am saying. Okay, so you're all quickly reading. Go ahead. Dr. Robert, who has PhD from USA in genetic science, who is 20 years old. Mr. Simon, who has been adjudged and insolvent. Mr. Peter, who was convicted for an offense under the FEMA and sentenced for 1 year. And see, you'll notice that I'm also carefully using the word only sentenced. Sentenced. I'm also not using imprisonment. I'm also playing it safe because where in the section does it talk about imprisonment? Sentence it is. Punishment. Sentence has meanings in English. Sentence, a set of words forming a meaning. When you put together words, okay, they have a subject, a predicate, and a verb, then it is a sentence. Okay. Hi is not a sentence. How are you is a sentence, an interrogative sentence. You, how are. Verb is there. How are you? Subject is there, predicate is there. How are you? Sentence. But that is English sentence. Law sentence is order of the court punishing somebody is called a sentence. When the court passes an order levying a penalty, especially levying an imprisonment, ordering imprisonment, that is called sentenced. Even death, that is called a sentence. That's why it's called death sentence. Somebody is given a death sentence. That means the punishment is death. Like that. Okay. So any order of the court which talks about a punishment to be given is called a sentence. So such a person is called sentenced. Hopefully, since the word sentence does not talk about imprisonment, okay, you cannot be sentenced to death for 1 year. You can be sentenced to death, period. That's all. What if Mr. Peter has been sentenced for 3 months? How about Mr. Methuselah? I don't know if those of you who are well versed with the Bible will remember who is Methuselah. Right? Grandfather of Noah. Lamech was the father. Lamech's father is Methuselah. His father was Enoch. Okay. Noah, of course, had 3 sons, Shem, Japheth, Shem, and Ham. And some others also, they say, we do not know. Okay. Now, so Methuselah is 92 years old and still going strong. Can we appoint him? Okay, let us see the answer. So, he says, no. Yes, wow, that's good one. No, absolutely correct, Ms. Kodali. A no, B no, C no, D no. Okay. D, C, of course, has an option. Okay. Got it. All of you are correct. It is a pity that, we can't appoint Dr. Robert. Excellent. You understood well. So happy. Now we come to the crux, not the horcrux, the crux of the crux is the core, the crucial part. That's why it's called crux. The crux of the core part of the topic, managerial remuneration, which is Schedule 5. What I'm doing is, I'm going to discuss the broadly Schedule 5 to you. Then I will start discussing the provisions relating to managerial remuneration. You might ask me, why are you taking up Schedule 5? Should you not go to 197 first? Totally agree with you, my dear friends. But please understand, 197 is built into Schedule 5. Section 197 deals with managerial remuneration where there is adequate profit. That is Section 1 of Part 1. Section 1 of Schedule 5. So that is all covered here. In other words, Schedule 5 is subject to 197. So Schedule 5 is not an exception to 197. It is not as if you cannot pay them that remuneration, you come to Schedule 5. No. The only exceptional part is Section 2, which is possibly very important. Section 2 is where we talk about effective capital, where we talk about effective capital limits, and even in an year of loss, where there is no profit or inadequate profit, you can still pay some salary. Some salary. Okay, you can pay, right? Then, of course, we'll be seeing. So, Part 1 contains the conditions to be fulfilled for the appointment of MD, WTRM without the approval of central government. Please understand. That is what I told you. We've seen disqualifications now. These are disqualifications for all people. Through Schedule 5, be able to pay them remuneration even in a year of no profit or inadequate profit. Then, if you want to go through Schedule 5, then you have to comply with the stringent conditions prescribed in Part 1. So, Part 1 contains the conditions to be fulfilled. So, if the guy has not fulfilled the conditions, you have to go to central government for approval. So, nothing, no problem. You still have an option. You can go to the central government. Central government will have discretionary power. They may refuse also. But if he is satisfying these conditions, then no problem. You appoint him for 5 years. Where there is adequate profit, pay him 197 full, 10%, 5%, enjoy. Where the profit is not adequate, go to Section 2. See, this is the advantage of appointing a person through Schedule 5. You understand? I appoint him under Schedule 5 for 5 years. Means I tell him, I appoint him and saying subject to the provisions of Section 187 in Schedule 5, we appoint him for 5 years. Which means what? If he is otherwise satisfying Part 1, then year of adequate profit 197 will apply. No problem. Pay him full. Enjoy. Year of loss, you don't have to go to central government. You are anyway under Schedule 5. You pay him the salary, minimum salary that you'll be seeing later. If you still want to pay more, you go to central government again if you want. So this way Schedule 5 gives you an open route. See, this is the intention of Schedule 5 and the idea was if you are satisfying the criteria, if you are otherwise within the limit, don't come to me, pay and go. But any issue is there, you want to go beyond that, come to me. That was central government's view. Now they have made it even more liberal. You'll be seeing, okay, so that you can pay them a decent salary and all. Now, Section 3 is exceptions. We'll be seeing that. Section 4 gives some perquisites not included in remuneration. Actually, they are not much. Okay. Otherwise, you'll be seeing remuneration will be defined very clearly. It includes all perquisites defined under the Income Tax Act. Anything which is a perquisite under the Income Tax Act is to be included for the purpose of managerial remuneration under the Companies Act. I will repeat it when we come there again. Then procedural aspects. Some procedures are there. Otherwise, company secretaries will not get income. So some procedural aspects are there. Blah, blah, blah. Chalo. Let him enjoy some. He should have some procedures. Otherwise, he'll not. If they don't have a form, they'll not know what to do. So better give him some forms and ask him to go and fill it. And power of central exempt in certain cases. Right? So this is the schema. This is the broad diagram of Schedule 5. Okay. Good. Now, Mr. Ranveer has given very detailed answers. I'm very happy. Thank you, Mr. Ranveer, for that. So what I have given is the broad schema of Schedule 5. Try to put this in your brain. Even if you want, of course, I will be uploading this notes at the end of these 3 sessions. Once I complete my 3rd session, my entire notes will get uploaded, right? Don't worry. Some people say, put it up beforehand so that we will study and come. No need. I want this to be the first time you will look at it with me. Again, neuro-linguistic programming wise, NLP wise, I want this to be the first time you look at these slides so that the way I am telling it now, it will get imprinted in your mind. If you go through it earlier, believe me, you won't have the same effect. Later, once I have put it into your brain, it is there, then you read it again and again, it will be easy for you in the exam. Today, right, I just want you to have a look at this. If you want, take a photo of this slide from your laptop. Maybe if you want to have quick revision tomorrow, because once you become familiar with this now, part 1, part 2, part 3, part 4. Part 1, condition. Part 2, section 1, where there is adequate profit. Section 2, effective capital, where there is inadequate profit or loss. Section effective capital, salary can be paid. Section 3 gives exceptions. Section 4, perquisites. Section 5 talks about very rare case where the fellow wants to get remuneration from 2 companies. Right? Then procedural aspects and power of central government exempt. In fact, can a person be MD in more than one company? Answer should be no, right? But they give an exception. We'll see that. He can be in more than one company. We'll see that. But then how to pay remuneration? Section 5 talks about it. And procedural aspects are there. Part 3, part 4, power of central government to exempt, right? Now, we are talking about 197. That's why I mentioned one. Some of you maybe already have studied the material, so you'll be really angry and worrying. This fellow is not talking about 197. He's going to Schedule 5. Maybe he doesn't know the subject. Could be. But again and again, they are not alag-alag. They are single provision. 197 is the substantive framework. Schedule 5 is the framework. Work together. Schedule is not an exception to 197. It is part of the 197, right? And what we should do while appointing subject to the provisions of section 197 and Schedule 5. If you forget Schedule 5 and you just put him under 197, in an year of loss or inadequate profit, you'll be in shit. Because then you'll have to go to central government for approval, etc., etc. You might have to capital. So better bring him under Schedule 5. But remember, if you want to appoint him only under 197, no problem. These disqualifications, right? But if you want to appoint him under Schedule 5, to satisfy the conditions mentioned in Part 1, which is more stringent. If he is not satisfying, then you cannot appoint him under Schedule 5. Remember, and in a year of loss, you will have to go to the central government and get approval. Got it? This is why Schedule 5 is very important. Friends, thought to sink. Man who has not satisfied all the conditions under Schedule 5 cannot go through Schedule 5. In which case, you can still appoint him as MD if he is satisfying the broader disqualifications are not applicable. No problem. You can appoint him as MD under 197. But in an year of loss, sorry, you cannot pay salary, balary. Whatever you want to pay, go to the central government, get it approved and come back. Okay, that is all. Now, the terms and conditions of such appointment and remuneration payable shall be approved by the board of directors at a meeting. No problem. Then you should get the approval by passing a resolution, ordinary resolution, at the next general meeting of the company. Anytime, you don't have to hold a general meeting and get prior approval. But after the appointment with the board, at the next general meeting, you have to get the approval from the shareholders. In case such appointment is at variance with conditions specified in Part 1 of Schedule 5, approval of central government shall be obtained by applying in form number MR2. That's what I've been telling. You can, if you are not satisfying the conditions, then go to central government for approval and then. Okay. The notice convening the board of or general meeting for considering such appointment shall include the terms and conditions and such other matters, including means whether he is trusted director in any matter, etc., etc. For example, he may be an MD here and part-time director, or sorry, non-executive director somewhere, whatever. All that has to be told. And okay, after appointing him, you have to file a return in form number MR1, which shall be filed within 60 days. So form MR1 is the return of appointment of managerial personnel. MR1 filed within 60 days. Whereas government approved in form number MR2. Okay. We saw that board can appoint, but it has to be approved by the members at the next general meeting. What happens if the appointment of MD, WTD or YM is not approved by the company at general meeting? His appointment will cease to be valid from the date of the general meeting. Please understand. We appointed him, let us say we appointed him in April or May. Then in October we had an August we had an AGM. At the AGM we presented the appointment for approval. Shareholder said sorry. Now he will cease to be MD only from the date of that AGM or that general meeting. Okay. Any act done by him before his appointment was so disapproved will be valid. Any act done by him before such disapproval shall not be deemed to be invalid. So otherwise who can work? Yeah, suddenly they disapprove him, everything becomes invalid. No. More importantly, you have to protect third parties, right? Third parties are getting, in good faith, they are entering into a contract with the company. This guy is signing them. Suddenly we say he is not MD, he is disapproved. Then anything done by him till such date is valid. After that, if he continues, not only it is invalid, he is also liable. Okay. I think this is a general rule applicable to most cases. See, later on we'll be finding tribunal can remove MD, WTD and all we saw. Now, even there we will find when you go to oppression and mismanagement, when the power of tribunal to appoint will be discussed, they will very clearly say, acts done by him up to that date is valid. Beyond that date, not valid. Right? Of course, subject to any criminal acts done by him will be punishable. The act, if it is legal, within his power, not ultravise his own power, everything is valid, then those acts are valid. Suppose he has done some criminal thing, sorry, that will come under a different case where he will be punished and will be described separately. When you come to oppression and mismanagement, just link it with this. Because there you will find one of the powers of the tribunal is removal of managerial personnel. It will be good if you know how to link topics. Okay? Don't read these chapters as compartments. They are not. They are one seamless law. In fact, the institute artificially creates a compartment for you and says, before a particular section is not in your syllabus. I would humbly differ. In the sense, not differ, I would humbly suggest that you shouldn't think like that. Those things that you studied in the intermediate are still relevant. Not from the exam point of view, but from understanding the words. Some words have already been including some of these definitions were taught to you in your intermediate, when possibly they were not relevant. Now they are relevant. That's why even though some of you could argue that you are going out of syllabus, sir, that is not in my syllabus, sir. I know, but to help you understand, I am doing this. Good. The provisions of sections 2, 4 and 5 of section 196 pertaining to tenure of appointment of MD, WTD or M, procedure for appointment, consequences and non-approval by shareholders do not apply to government companies. See why I'm making these things clear now. Entire 196 is not made not applicable. Only 2, 4 and 5 which deal with these topics. That is not applicable to government companies. Okay. Only these 2, 4 and 5 etc. Similarly, the provisions of 4 and 5 pertaining to procedure for appointment of MD and WTD, consequence of non-approval do not apply to private companies. Okay. So private companies, procedure for appointment is not applicable. You can appoint any day, any amount, anybody. You can pay him anything you want. Private companies can run naked. Nobody is asking them any questions. All these stringent rules apply only to public companies and, of course, public companies. Government companies are also exempted. Private companies can run naked. Nobody is asking them any questions. Do whatever you want. It's your money. You do whatever. But public companies, no. Okay, got it? Earlier, before this 2015 notification, these sections were made applicable to all companies, and they were really painful for private companies. See, earlier, private companies were quietly exempted in all cases. In fact, most sections will exempt private companies straight away. Straight away, the section itself will exempt. When this law came, it was a nightmare for us. Because all the sections will be applicable to private companies also. And private companies, they don't have the maturity to comply. So we were all, including 185, 186, we have to run to MCA. And those guys, once they drafted the law, according to them, it is like the 10 commandments given by God. Okay, even the 10 commandments could be changed. But this company law cannot be amended by these fellows. That's what they were telling. Finally, they ended up amending it. Of course, they will not amend it. Instead, what they will do, they will give notification. And they will use the rule-making power to create rules, etc. All nonsense. Which is why this whole law has become an unwieldy set of section, rule, notification, circular, blah, blah. Need not be. It can be a nice substantive law with decent procedural law rules and all. That is all. All that was needed was that. Instead, they have made a mess. See, section also will talk about this subject. Duplicate. If there is any conflict, all sorts of confusion, people saying, if there is a conflict between section and rule, section only will prevail, not the rule. Section is a substantive law. Rule cannot prevail, or rule cannot take away something that is given by the section. Rule cannot make something more stringent than what the section does. Rule, if the section says it can be relaxed, rule can relax. But rule cannot make it more stringent. Okay? Rule can only relax. If at all the power has been given to the executive authority. But the executive cannot make the law tougher than the parliament itself. The intention of parliament should be more important than the executive power. This is well known, and maybe some of you already aware, but I thought I will share with you. Remuneration, any money or its equivalent given or passed to any person for services rendered by him, and includes perquisites as defined under the Income Tax Act 1961. So, while calculating managerial remuneration, you have to include all the perquisites. Got it? Your good old Income Tax Act, everything, rent-free furnished accommodation, provision of motor car, you limit any amount that the employee should have paid, which is borne by the employer, perquisite. ESOP, perquisite, to the extent of the difference between the fair market value and the ESOP price, perquisite, everything included. Then and only then should you apply the limits. We'll be seeing. So, go back. That is why, for the purpose of Schedule 5, they will exempt a few items and say, hey, these are not perquisites, can be excluded. Very, very small item, nothing great. Now, remuneration determined under Section 197 and Schedule 5 shall be inclusive of the remuneration payable to him for services rendered by him in any other capacity. For example, simple. Mr. X is the MD of Dubacor Limited. You want to pay him some salary. There's some limit problem. It so happens that this guy has got some sales experience. He's been a salesman in some company. You want to pay him. Chalo. Don't give him a salary. Call him a consultant. Give him a consulting. Simple this. Even if you pay consulting fees, also included for the purpose of remuneration. So, services rendered by him in any other capacity will also be included. So this, this all-pervasive term, consultant, cannot be applied. If you say consulting fees, that is also included. So 194, or rather I'll put it differently, it will be easy. Whether it is Form 16 or Form 16A, you are paying him, he is a managerial person, MD, WDM, you are paying him It doesn't matter whether TDS is under Form 16 or Form 16A. Okay, you simply 194 or 194J, it doesn't matter. If he is liable, you have to, if you're paying him, it is part of remuneration. Some notable exceptions are, be careful. While calculating, while including remuneration, services rendered by any such director in any other capacity shall not be so included if the services rendered are of a professional nature. Professional services. For example, Mr. A is the leading chartered accountant. He is also a director. He is also providing tax advisory services. He is not independent, that's all. He is not independent, that's all. Nothing, no crime. A director can be a consultant. Nothing wrong. And tax advisor, nothing wrong. And he can bill. But that money will not be included for calculating managerial remuneration. Why? Because the services rendered by him are of a professional nature. Got the point? And then, of course, they also put the condition, the services rendered are of a professional nature and the director possesses the requisite qualification for the practice of the profession. So here they have given the full power to the board or the nomination and remuneration committee, as the case may be. So they have left it to the board or the nomination and remuneration committee. Friends, I am being very careful here. The word profession is a wide term. I have given you a simple example. Chartered accountant. I am a chartered accountant. I am also now training to become an astrologer. I'm not joking. During the pandemic, I started studying astrology, Vedic astrology, and I have completed my. There again, they have lower and higher. Completed my advanced year, which is very tough. It's going to take me another 5 years before I come to advanced year. What 60 plus, I want to take up another profession is astrology. Now, suppose I become director of a company. I'm an astrologer. So the MD says he's a believer in astrologer. So Srikanji, you come on my board. Yes, sir. Also, you tell me when is the correct time for me to start the new factory. No, that is no, Srikanji, whatever you want to charge, you charge me. Chalo. You give me fees. I will go through all the stars, your star, your wife's star, company ka star. Then I will put it and then I'll give you a time. At that time, if you start, your business will go up. Now, does this amount to professional service? Sorry. Yes, it does. It is a professional service. Astrology is a professional service. Vastu consultant, professional service. Architect, of course, professional service. Interior, professional service. Okay, all that is professional service. Okay, sorry. Don't get angry with me. In the earlier law, there was a separate circular where you will find all these are included. Vastu consultant, separate service. Specialization in astrology. Vastu is part of astrology, but Vastu consultant is separate. Gemology is separate. Okay. So why I'm telling you this, some of you shouldn't get angry with me, but just to tell you, the word profession is a very wide term. And good. Now, moving on. See, this suddenly, if you put yes, sir, and all, I get really worried. Just put some Ms. Kodali should put some words. So, according to her, astrology is a profession. Thank you. Because at this rate, I'm very worried about CA. Because at this rate, I am told everything is going to be a problem. Income Tax Act is going to become very, very simple. Everything is going to be simplified. Okay, and the law will become simpler and simpler. Company law will be extremely simplified. No need for chartered accountant practicing. Services, you will all be needed. Service, you will be needed. But practicing CA, no need. Another 5 years, no more need for you guys. Get out. And the Companies Act also will be amended. No need for auditing. No need for tax audit. Self-audit. Okay. Whatever. Who cares? Okay. All you get out. Then at least I should have some other profession, right? That is why I'm studying astrology. Just joking. Huh? I don't know about that. So better to keep ourselves with some other activities, what I was thinking. Because people keep on threatening. Every time in WhatsApp, some news will come. Central government, MCA proposing to remove compulsory audit of private companies. Companies up to whatever they comes to their mind. 10 no need for statute. No need for like they'll keep doing all sorts of some of my peers will forward it and say what to do like that. I'll tell him See, for me, no problem. 57. I'll 60. I may even take sannyas and I will go. Okay, for me, no problem. You guys better equip yourself with some other profession. That's all I will say. Okay, just joking. Don't take me very seriously. It will not be like that. I am having highest confidence in the government of this country to complicate the law further and further, make the law even more tough, so that our services will be continuously required by the citizens of this country. They will continue to come to us for consultation. Don't worry. Another 2 generations of our profession will serve it. Don't worry about that. Okay. 100%. I have that much confidence in our government and their inability to make simple laws. Okay. Now we jump into Schedule 5. Straight. Schedule 5. So the conditions to be fulfilled. Okay, regarding break. Before somebody says, I want a break, let me tell you, break at 7:45. So hold on. Let's go a little bit deeper into Schedule 5 and let's learn a little more. Then I will give a break. Okay? Wait till 7:45. Then we'll have a break. Then we'll go on till 9. Maybe 10 minutes break, then we'll go on till 9. Okay? I know this is little dry, but just hold on with me. One easy way to make it interesting is for us, you can raise doubts. Again, see, in those days, I'm very surprised. A lot of people will ask all sorts of doubts, and I used to get them doubts and all. This batch, I'm not finding that much doubts. Not doubts, questions will come. Like Darasha is the only person who. Vanacharla used to be there, but Vanacharla is not available now. Maybe he's busy or whatever. Maybe he's planning to download the lectures and listen. I don't know. He used to ask a lot of nice questions. And all that. Soham also used to ask questions. So agree. Suppose you are still comfortable, everything is clear, sir. Why should we ask questions? No problem. But if you do have a question, just put it on the query pad. Because sometimes students ask very, very smart questions. And I get educated by the answers. One thing. Mr. K. Gayatri, are the Indian laws are that complicated when compared to other countries? Yeah, my humble view, yes. And my humble view, yes. If you have a doubt, just download some Singapore laws and read it. Fairly simple, fairly simple. And at least the language is simple. See, the law in England is very, very simple. US laws are the simplest, but obeying it is tough. In India, the problem is we keep creating exception after exception after exception. Proviso, and we get into trouble. There, straight away, you obey, don't obey. If you obey, go. Don't obey, go to jail. Simple. Australia, simple laws. Drafted very simple words. No need for all this thing. This is my view, humble view of a man based on his own limited experience of foreign laws. But to answer a question asked very correctly by you, see, no Indian law is born complicated. The intention of Parliament, the intention of the Finance Minister, the intention of the Minister for Corporate Affairs is honorable. We want to provide simple law for you. We all expect simple law. But while drafting only, all the problem starts. They don't know how to draft. They keep confusing. Then they are afraid, paranoia, how they will violate the law. So in order to fill the loopholes, they will start putting all sorts of conditions, blah, blah, blah. Law will become complicated. While putting the condition, they will put a loophole also. And in that loophole, our friends will go through. And then they'll plug the loophole. Then this is how the law becomes complicated. Otherwise, Income Tax Act can be fairly simple. Believe me, within certain limits, certain values of simplicity, if we can make it simple. So otherwise, see, take for example, GST. Laudable goal, single, one country, one tax. Where is one country, one tax? You got RCM, you got some, what is that, blocked credits, and you got 3 different rates, and the IGST and CGST, SGST cannot be set off in some cases. So where is the one law, one country? Sorry, one tax, one country, one country. I'm not, this is no way commenting about our enlightened Prime Minister. No, his desires are honorable. He wanted one country, one tax. But while drafting is when the problem starts. You understand? Where the states are not able to come to an understanding as to how to share, automatically the complications start. And people get into trouble. That is how the complications come. See, you should be tough. That's why I said go to Singapore law. Singapore laws are very clear. Obey, don't obey. Obey, enjoy. We will give you a perfect freedom, enjoyment, enjoy Singapore. Disobey, go to jail. Straight away, no talking, no exceptions, no lawyer, nothing. You got a lawyer, come. He will come and say, yeah, he's guilty. Take the punishment and go. That's all. Legal representation is very much there. It is not a dictatorship. But if you have not obeyed the law, you will be punished. That's all. No loopholes. No profession like us, where many times, when in those days when I was studying income tax, somewhere there used to be a feeling that, and I'm just sharing my thought with you, kindly bear with me. There used to be a feeling that chartered accountant is somebody, the intelligence of a CA student in income tax was not judged by his knowledge of the law, but by his ability to twist the law and to help the client within courts to disobey the law. I was always against that. I said, look here, if that is the way I am going to get my fame, if that is the way I'm going to be seen as a great chartered accountant, boss, I don't want. Beauty is, I practice direct taxes. One of my bread and butter of my practice is direct tax. No doubt about it. I give advice to my clients, but I interpret the law for them. And I tell them, this is the law. Obey it. This is beyond the law. Go there, I will. But there are some, but unfortunately, when I find that, I find the law itself vagueness. So if I tell the client, obey the law, it will be unfair to the client, no? So I then call him and say, look here, this is the law. This is the decision of that is when the problem starts. This is the law. This is the decision of the Supreme Court on similar facts. This is the decision of the Bombay High Court on similar facts. This is the decision of the Madras Tribunal on similar facts. Madras Tribunal says differently. Bombay High Court is in your favor. Bombay High Court will go to Supreme Court, or this fellow may go to Supreme Court. Finally, when Supreme Court gives the order, what you are now doing, currently wrong in Tamil Nadu, may be correct later. Now, how can I advise him? So I'll tell him, boss, don't pay. Pay 20%, go on appeal. Sit. Tight. We'll go to tribunal. Tight. We'll go to High Court. Tight. In the meantime, we'll get a stay for your demand and wait. That's all. Now, a whole profession is born out of this. For doing all this nonsense, we need people who will do it. So if that is how we have to redefine ourselves. Okay. But even then, I don't take any pride in interpreting the law in such a way as to not to pay taxes. Sorry. That is not my intention. And I would humbly suggest, as now that you people have attended the 4th lecture of mine, some of you may be looking at me as a guru or as a teacher. If you have such a mental association with me, take it from me. Please do not engage in helping criminals and crooks. That is not why you are studying. That is not why you are going through the STUF exam, to become an advisor or some sort of helper for these criminals and crooks. Advise good people on how to comply with the law, make them successful in business, make them earn crores and crores. They will pay you crores and crores and you will become rich. That is the best way to become rich, rather than, finding out loopholes in the law and helping these fellows to go through it. So think about it. This is my view. I'm giving this as a guru and as a teacher and as a senior member of the institute with 35 years of practice, for what it is worth. Again, okay. And so kindly take it in the right spirit. Keep it in your mind. Okay? Good. Moving on. Coming to the crux of our topic, Schedule 5. Crux of the crux. Schedule 5. Now, we have entered Schedule 5, Part 1. I told you, conditions to be fulfilled for the appointment of MD, WTD or M without the approval of central government. No person shall be eligible for appointment as MD, managing or whole-time director or manager of a company unless he satisfies the following conditions. So, to become MD, M or WTD, you have to satisfy the following conditions. Condition A. See, here he has been sentenced for a period of more than 1 year, right? Here, they are identifying specific laws. And they are saying he had not been sentenced to imprisonment for any period. There, more than 1 year. Here, even 1 day. If he has been sentenced to imprisonment for 1 day, or to a fine exceeding 1,000 rupees, even fine, up to now, for director, 197 MD, we have seen only imprisonment. For the first time, we are having fine, even exceeding 1,000, fine of 1,001 rupees for the conviction of an offense under any of the following acts. So, under any of these 19 laws, if he has committed an offense and has been sentenced to imprisonment for any period or fine exceeding 1,000 rupees, then he cannot be appointed as MD under Schedule 5 or WTD under Schedule 5. He can be appointed as MD because there 1 year is there. But here, under these laws, even for 1 day, he cannot be MD of a company under Schedule 5. You have to go to central government for approval. Got the difference? So these laws and all, if you can remember, it's don't worry. See, Indian Stamp Act, yes, Central Excise Salt Act, removed. Industries Development Act, removed, repealed. Prevention of food adulteration, very much there. See, this is one important law. Suppose the company is engaged in manufacturing food products, and there is a poisoning or some adulteration. Somebody dies. Straight away, criminal liability on the MD. Straight away, under the Prevention of Food Adulteration Act. Okay, the essential companies or Indian company SCRA in your syllabus, now they removed it. Wealth Tax Act repealed, Income Tax Act not yet. Customs Act very much. Competition Act yes. FEMA yes. SICA yes. SEBI yes. Actually, SICA it is repealed. Instead, you have the IBC, the Insolvency and Bankruptcy Code. To the extent that certain provisions are still there, they're retaining it. SEBI, you know that. FT, Foreign Trade Development and Regulation Act. Prevention of Money Laundering Act. To my knowledge, it is there in your syllabus. The IBC, Insolvency and Bankruptcy Code, is there in your syllabus. Goods and Services Tax, 2017, GST, and the Fugitive Economic Offenders Act, wow, 2018. That is a new addition. I think you know who is being aimed here. Fugitive Economic Offenders. There are a few big names now. Nirav Modi, Mr. Vijay Mallya, etc. etc. You know, I go to Sabrimala regularly. I'm a regular devotee of Sabrimala, and see, every time I go there, I see, you know, I don't know, next time if at all you go to Sabrimala, you just, when you are climbing those 18 steps now, a little bit before that, there will be one set of stairs. Before you climb those stairs, on the left-hand side, you will find that there is a plaque where, you know, Vijay Mallya has contributed that golden roof of the temple was fully donated by Vijay Mallya. I don't know. I used to be highly inspired by that, by this devotion of the gentleman that he was, I mean, okay, he gave it because he had the money, but at least he had the thing to give the money. So, like that. But then, after all these things have happened, I don't know whether I'm right in appreciating him or not. See how people from highest levels of greatness, they fall to becoming like this. Whatever it is, such people cannot be appointed as MDs of under Schedule 5. Okay. If you come under this net, straight away you have to go to central government for approval. Straight away. If you want to appoint through Schedule 5, please, boss, fellow has committed offences, he has been fined 2,000 rupees. No problem. Company is making enough profit. You can pay him his salary. You don't have to go to anybody and get any approval. The minute there is inadequate profit, only you'll be in trouble. Then you want to go through Schedule 5, and this problem is there. You have to go to central government. B. This is B. He had not been detained for any period under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, popularly known as COFEPOSA. COFEPOSA. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. Simple. Mumbai International Airport. He's got a briefcase. Then the customs authorities call him, Mr. X, please come this side, we want to check. They open the suitcase, nothing, everything, only change of clothes. He says, sir, I just went for a day trip to Dubai and coming back, no problem. Then they shake the suitcase, then suddenly something happens. They slice through the lining, the lining, and there they find gold is there. He has smuggled gold, he's bringing gold. Okay. Straight away, he can be detained under COFEPOSA. Because why are you bringing gold? What is your reason? Do you have any bill? Have you purchased it? If so, is it within the limit, etc., etc.? Nothing. He's simply smuggling gold. Okay. So you see that way you save on import duty. No other reason. Okay. Immediately they will detain him under Cafe Posa. Also, this is Cafe Posa and PMLA are closely linked. Money also going on here. Or he can be detained for 48 hours. That's all. See, the detention under Cafe Posa also serve. There are other laws also. Narcotics Act also is there. Both these laws, he can be detained. Provided under that law, he should be found in possession of contraband. In possession means what? When the customs in his hand, he should be caught. That's it. Then he can't do anything. He will have the right to a lawyer, etc., etc. But for 48 hours, I can detain him. The reason I can detain him is, see, after all, this fellow who is coming with the gold is not the main man. The main man is somebody else. I have a chance to find out some of those fellows. I can take him inside and question him, keep asking him questions, and try to gain something. So imagine a person who has been detained even for one night by customs people under Cafe Posa. Is he a worthy man to be appointed as an MD of a company? He is, because otherwise he is qualified. Under Schedule 5, I cannot appoint him. That's all. Okay. He can be a director and all, but I cannot appoint him under Schedule 5. That's all. Now you understand the 3 hoops example. He can be a director. He can even be MD under 187. But if you want to appoint him under Schedule 5, sorry, if he has been detained, he cannot be. Where the central government has given its approval to the appointment of a person convicted or detained under subparagraph A or B above. So, person has been convicted, or then you go to central government. So, central government says, okay, this time I will permit you, go. No further approval will be necessary for subsequent appointment. Provided he has not been so convicted or detained subsequent to such approval. I'm really happy about the way Parliament is so happy, free. Now it says, see, look here, we are permitting you now, go. Don't make the same offense again. Then you can be reappointed. As if, you're encouraging this fellow to be convicted. Okay. But so long as he has not been a bad boy in the meantime, he can be again reappointed once he is approved by the central government. Right? Good. Again, same conditions are there. 21 years, 70 years, blah, blah. Person above 70 years may be appointed with passing a special resolution. If special resolution has been passed, then no further approval of central government is necessary. But if the members have not passed a special resolution, go to central government for. So similar, see, this there in that section also. Again, they are given in Schedule 5. No problem. Enjoy. Earlier, main section. Only Schedule 30. Now they are put in both the places. So, super, enjoy. He is resident of India. Friends, the word resident is very, very dangerous term. Never use it loosely. Always ask under which law. Because there is one definition under the Income Tax Act. There is another definition which you will be seeing under FEMA. Person resident in India, person resident outside. Here they give only for the purpose of 5, not even the 2013. For the purpose of this schedule, resident in India includes a person who has been staying in India for a continuous period less than 12 months immediately preceding the date of his appointment as a managerial person. So, the person, if you want to appoint him under Schedule 5, he should have been staying in India for a continuous period of not less than 12 months immediately preceding the date of his appointment as a managerial person, and who has come to stay in India for taking up employment in India or for carrying on a business or vocation in India. So, he should have stayed in India for not less than 12 months immediately preceding the date, and he should have come to India for taking employment or carrying on business or vocation in India. So, the word resident is very carefully worded. Okay, if you want to go through Schedule 5. So, for example, a foreigner who comes to India, even for employment, if he has not stayed for not less than 12 months immediately preceding, he cannot be appointed under Schedule 5. So, what you will do is you appoint him for the first time with approval of central government. Let him stay in India 12 months. Then you will go through Schedule 5. Condition regarding residence shall not apply to the companies in SEZ. See, special economic zone companies are set up by foreign companies. Many of these companies are owned by, or they are subsidiaries of foreign companies. So sometimes an expat, person of Indian origin, but a citizen of US or a citizen of Singapore or a citizen of UK or Canada may become the MD. Now, see, we want to encourage SEZs. So there you cannot go to Andrew or Robert and tell him, hey, you cannot be an MD because we got Schedule 5. So they say, SEZ wala, no problem, boss. If you're appointing an MD in the SEZ, enjoy. You don't have to get my approval. If this definition of residence will not apply to appointment in SEZ, right? SEZs are notified by Department of Commerce, no problem. But that non-resident in India should enter India only after obtaining proper employment visa and all from the Indian mission abroad. So the idea is he can come and start working in India. The norms he has. We move on to part 2. Part 2 consists of many sections. Many sections. Okay. Part 2 consists of many sections. Okay, we saw that now. 5 sections are there. 5 sections are there. That's section 1. Section 1. Section 1 is the easiest section. Okay? Because remuneration payable by companies having profits. You calculate the profits as per. Later on, we'll be seeing section 198, wherein we will talk about how the profits are to be calculated. I'm sure because you are also studying another topic called auditing. In auditing also, you would have studied the same topic. Why? Because there, for the purpose of auditing, you should know how to compute the managerial remuneration. Profit for the purpose of section 187, according to section 188, maybe you would have studied there as part of your, or even accounting or auditing. This is the legal aspect of it. Okay. So, if you compute the profits in accordance with section 188 and you get a number, on that number you calculate the limit. I'll be telling that limit very short. You calculate that limit, you get an answer. That limit is much more than the salary you are proposing to pay or equal to or little more than the limit, then no problem, enjoy. Okay, the limits are there. You calculate the profit, apply the limits, compare that number with the amount you are going to pay to these guys. What you're going to pay is less, then no problem. Enjoy. Go through part 2. Simply pass a board resolution, approval by shareholders. That's all. Enjoy, run. Now, so subject to the provisions of section 197. See, if you appoint him through Schedule 5 for once, and in every year there is adequate profit, no need for approval from anybody. Just simply pay him. Okay. So, see what they are saying here. Subject to the provisions of section 197. So, Schedule 5 is subject to section 197. So, we are seeing 197 actually. Whatever limits are prescribed under 197 are applicable here. Schedule 5 cannot be more than 197. Please understand. If you want to pay more than 197, you have to go to central government for approval. The percentages. Within section 197, you can pay anything, provided under part 2, section 1. A company having profits in a financial year may pay or director with specific directors was introduced. This word is used, words are used, or other director or directors means non-executive director or an independent director. Okay. So even a non-executive director or independent director is eligible for remuneration in accordance with section 197. Right? Now, So I think it was a little heavy going, and it is high time we go for a tea. I'm sorry, cup of tea or coffee or whatever. So yeah, sometimes there could be an internet problem. It could be due to your problem also. Just to bear with it, because what I find is it gets corrected. See, we are dealing with a very delicate resource, the internet. So could be. And one thing, Daraji, is this: I cannot know whether you are able to hear or not. I can only continue to talk and pray to God that you should get what I'm saying. But the technical person who is also involved in this meeting, he is always watching. Suppose it becomes too unstable, he will call me and tell me. Till such time, I will possibly have to continue to talk. Anyway, let us give a small break for 10 minutes. Okay. For you, for me, break from speaking. For you, a break from listening. Right? So, break now. Welcome back from your well-deserved break, and I hope it is somewhat better now. Just in case you have, I don't know which part was actually missed, but let me quickly make the point. Schedule 5, Part 1, we have seen what are the conditions. If any of these conditions are not satisfied, you have to get the approval of the central government. We also saw the condition. We also saw the exemption peculiarly defined here. You can go through it. And if that is not satisfied, you have to get the approval of central government. See, this is a prohibition. You cannot appoint him under Schedule 5, which means in a year of loss or inadequate profit, you cannot pay remuneration unless you go to central government. But if you go through Schedule 5, even in a year of loss or inadequate profit, you can continue to pay him salary based on effective capital. In fact, in these two sentences, and I hope Darasha is able to hear what I'm saying, because this is the essence of Schedule 5, 190 Schedule 5. If you appoint a person, if you do not appoint a person at Schedule 5, then in a year of profit, no problem. Even if you are not in Schedule 5, in a year of profit, who can ask you any question? If the salary you are proposing to pay is within the limit prescribed under Section 197 based on your current year's profit, you are kings. Yeah. For example, Ambani is not going to ask anybody's permission, boss. Just go to what's the profit for managerial remuneration purpose. You'll be, Mr. Ambani can take n amount of salary, 3.5 crores per month also he can take, no problem. But 5 crores he can take. What is that? Okay. Per month. I'm not joking. Just go and see the profit and calculate the limit. Within the limit, no problem. But suppose in a year of loss or inadequate profit, and you still want to pay a salary to your managerial personnel, then that cannot be done if you fight. Saying these things are very, very important. Otherwise, so long as you satisfy that you are not disqualified under 187, no problem. The main disqualifications that we saw, if you are not hit by them, no problem. If any of these disqualifications are there, that conditions are not fulfilled, then no Schedule 5. But 187 is still there. You will be appointed under 187, which means if you go through Schedule 5, Part 2, Section 1 will apply to that situation. So Schedule 5 is a comprehensive code. Schedule 5 covers all situations. If you don't go through Schedule 5, then loss or inadequate profit is not covered for you. You have to go to central government for approval. That is all. You got my point? Now, so Part 2, Section 1. Remuneration payable by companies having profits. Subject to the provisions of 197, a company having profits in a financial year may pay remuneration to a managerial person or persons or other director or directors not exceeding the limits specified in such section. Right? So, for the purpose of Section 1, Section 2, and Section 3 of Schedule 5, Part 2, all these sections, 1, 2, 3, okay? The words or other director will be used. That non-executive director or an independent director. So, a non-executive director or independent director can be paid remuneration in accordance with Section 187, read with Schedule 5. We are going to see that. 3 sections, we are going to see how he will be paid. Okay? Now, if you know this already, no problem. There is a chance that some of you may be aware of it already, because you might have studied this for auditing. I have a feeling that you would have studied it for auditing. Even at the intermediate level itself, you would have studied it. I have a feeling. In case you did study, but you have forgotten or you have never attended that particular class, then I will cover this again here. No problem. This is part of the total. I'm covering it. These are limits where there is adequate profit, or rather you calculate profit level and you the profit, how to calculate 198. We will be seeing it later. That word net profit in accordance with Section 198. That will be seen later. So on that net profit calculated in computed in accordance with section 198, one whole-time director or managing director only, one WTD or MD only. If you have only one MD or WTD, then that one gentleman or lady can get 5% profits. Please, this does not mean a company can have only one WTD or MD. No. If there is only one WTD or MD, I should maybe use the words, where there is only one MD or WTD, then that one MD or WTD will get 5% of net profits. Where there is more than one MD or WTD, I told you can have more than one MD. Definitely can have more than one WTD. A person cannot be WTD in more than one company. A company can have more than one WTD or MD. Okay. Then, if you have only one MD, 5% for that fellow or that lady, no problem. But you have more than one MD, sir. I've got two MDs, sir. One MD, JMD. No, sir. I've got 4 WTD. Come on, whatever. 10% of net profits are all taken together. Enjoy. Calculate 10%, distribute it however you want. So long as supplement is 5% per guy, per person 5%, overall 10%. That's all. There's a cap there. You can't take more than totally 10% of net profits. Distribute it between yourself. 15 of them are there, 15 WTDs, no problem, yeah. 15 directors, all are WTD. Enjoy. Calculate 10%, take. If you want to take it as salary, take it. If you want to take it as commission at the end of the year, take it. Do whatever you want. Okay. Ideally, what we and hope for the best. Because see, remember, if fellow is paid salary and later on his appointment is not approved, then he has to refund. We'll see that later. He has to refund everything. Okay. There is a bit of a difficulty, but that's always there. Now, all part-time directors, please note the use of the word all. Later, I said, and maybe I will discuss that assignment also with you during class. You can have n number of part-time directors. Do you remember our Adekar board? How many were there? 15 were there. Do you remember that? Independent directors, 5. Non-executive directors, Palekar, Balekar. You remember Wagmare? So many people. Okay? Malati, Narsimhan, so many people were there. And then, of course, you had guys. Mr. Vikram Adekar. You had the JMD. Then you had Vimala also. So many people were there. Do you remember that? So 3 people. Now, let us say that in my example of Adekars, which I will be giving to you later, the 3 Adekars are WTD. With Mr. Vikram is the MD, Vimala and son Vimala are WTD. Whatever, all of them put together, 10%. The remaining people are all part-time, right? All of them put together 1% because there is MD or WTD. When there is MD or WTD, all part-time directors taken together get only 1%. Suppose the company does not have any MD or WTD. When there is no MD or WTD, the company is run by part-time directors. Fantastic, no? Only they'll just come attend one board meeting. In that board meeting, all decisions will be taken. The employees, then the employees will take care because these guys won't come on a day-to-day basis. They will go back and the company will be run by the employees and money will be made. Whatever it is, maximum, all of them put together can get only 3% of net profits for all taken together. Which is how you get your 11%. Suppose the company has one managing director, one JMD, one WTD. Or one MD, 2 WTDs, 3. All of them 10% take it. Now, where there is MD or WTD, all part-time directors put together 1%. So the total cannot be more than 11. That is that 11%. There is no 11% is not some number taken out of the hat. It is nothing but 10 plus 1, 11. Okay? Which is the ceiling limit for all categories taken together. Okay? Remuneration of the director, that is, for calculating remuneration, you should deduct remuneration. For calculating remuneration personnel, You cannot deduce the salary of the managerial person. What it is? Managerial remuneration after tax. You'll be seeing later on 180 after tax. I'm sorry. Before remuneration. What was the number? You calculate the remuneration payable to these people. Use that. You pay the tax because remuneration is a chunk of profits allowed deduction under the income tax act. After reducing that, whatever remains, you will calculate the tax and you will pay. Which is why for calculating managerial remuneration, you should not deduct tax. You understand? If such a provision has already been made, you add it back. You also add debit or debited. Whatever number you have, on that number you calculate the limits. Then see whether what you have paid or going to pay is less or more than that. Now, these percentages, remuneration for these percentages does not include sitting fees payable. Sitting fees is separate. So while calculating the remuneration, it is excluded of any sitting fees payable. So whatever sitting fees is extra, pay them. Got it? You want to exceed the limits. Friends, please understand, it is an year of profit. You are having profit. You want to pay more than 11%. Then the company in general meeting may authorize the payment of remuneration exceeding 11% of the net profits of the company, subject to the provisions of Schedule 5. You understand? If you want to exceed the limits, you can get a resolution passed by the members, but the candidates should be capable of being appointed under Schedule 5. You got the catch? This way, condition 1 becomes very, very important. Fellows, do not satisfy condition 1, then no question of exceeding 11%. Okay. So if you're already going through Schedule 5, no problem. You want to in any go to shareholders, tell they pay, take it, but subject to the provisions of Schedule 5. Understand how Schedule 5 is a seamless code. It is a complete code for managerial remuneration. I'm trying my best to help you to appreciate Schedule 5. In that process, 197 is built into it. See, the problem is when you read 197 first, then you read Schedule 5, you go mad. That is why what I have done now, I have mixed them. I have as a cocktail. I'm not giving it as a cocktail. There is no other way of doing it. If I teach you 7 Bear Act, then I teach you Schedule 5, I cannot do this connection. Therefore, kindly bear with me. The way I'm teaching, you may not find it in the Institute Ka material. No problem. You read the way in the Institute material, then come here, you'll understand that better. What seemed disjointed and what seemed a little not clear will become clearly falling in place. Like a jigsaw puzzle, it will come. 197 will come, Schedule 5 will come, conditions will come, Part 1 will come, Part 2, Section 1, we know there, and Section 2, everything will be clear. Okay. If a non-resident comes to India for employment and not in India for 12 months, can be appointed without taking a role? No, that is the problem now. Okay. See, friends, I totally appreciate your need, but I'm not going to do anything about it because the connectivity is not in my control. Sometimes it happens like this. So let me see. I don't know what I can do. Let me consult. Sir, technical, Mr. Nisar. Mr. Nisar, the students are coming, the connectivity is not good. Anything I can do about it? Correct. So what to do now? I will try to connect through some other connection. But you will have to tell me if it is okay or not. Is it somewhat better now? No, because students are continuously giving negative complaint to me about my connection, not about you, about me. That is why I want to be sure that things are fine. Still there's a problem, right? What to do? Sorry? What is that? No, I don't have an internet cable. I'm using only Wi-Fi. I will be using it now. Is it I don't know what to do. Connection I can do. Shall I wait for 5 minutes again? Try to come. I'll do that. Give me one. I'll move. Yeah, now I'm in another network. This is somewhat better. Okay. Let us get. So anybody is missed, they can always watch it in the recording. Okay. Thank you, Mr. Sir. Sorry to trouble you. Yeah, Ms. Gayatri, you'll have to bear with us. This is the best we can do today for you. In case you are not getting anything very clearly, I'm sure the recording would be clear. So you can go through the recording and you can listen to my lecture. There is the best option we can give you as of now. Coming to Mr. Kodali's question, we already saw that he cannot be appointed because if he is not resident within this definition, he cannot be appointed under Schedule 5. Again, my dear friends, if the profits are there, you don't have to answer to any burden. Year of profit, if you are able to pay them within this limits, 197, you don't have to bother, say resident, non-resident, anything. But the minute you are saying, I want to go through Schedule 5, I want to get the benefit of Schedule 5, then if he is not a resident, then you'll have to get the approval of central government. Got it? Now, suppose you want to pay one guy more than 5%. See, you have got one MD, one JMD, and one WTD. Now, you remember the overall ceiling limit is 10%. Within that 10%, any one director cannot get more than 5%. Cannot get. What do you want to do? Limits 11% you are still maintaining. But within that, you want to pay more. You want 7% rather than other directors are adjusting. Maybe it is within the limit, but this profit, even with part-time director, it's still within that 11% limit. No problem. Then you can increase the sublimit. Increase the sublimit, approve the company in general meeting by passing resolution. In fact, this is liberalization. So limits that are not what companies. It is not if they have to be, you are bound by them. You can increase. Provided you go to this company, this time we are going to, if they special enjoy. If you want to exceed the limits, then if the company defaulted in pay of dues to any bank or PFI or non-convertible debenture holders or any other secured creditor, then the prior approval of the bank, PFI, secured creditor or non-convertible debenture holder, etc., shall be obtained by the company before obtaining the approval in meeting. So, within the limits, you go ahead and pay. But if you have got some default with them and you want to pay more, then, no, I'm sorry, this doesn't apply to, this is applicable to all cases. Where there is a default, then before you get the approval in the general meeting by the members, you have to get the prior approval of the bank or the PFA, etc. Concept is very simple. Company has defaulted to bank or PFI. PFI is public financial institution, or non-convertible debenture holders are there, or any other secured creditor is there. Those guys are all waiting. You're not paid principal. You have skipped the installment. You are not paid interest to them. You want to pay remuneration to yourself. Because there is a profit also, you have to get their prior approval. So if they are willing to give you, take it. Suppose they are saying, okay, we will reschedule your loan. In the meantime, you take the remuneration. You have to get the prior approval of the PFI. Actually, this is, I tell you, there is nothing wrong about the law. Anytime when I complain, if I'm complaining about the 2013 law, the intentions are honorable. In fact, the measures that have been introduced are exceedingly good. Here is a fantastic method by which they want to protect the bank, PFI and all. So that any person who is the MD, before he wants to take remuneration, even within the limit, he has to go back, provided there is no default. So minimum what he will do, if he wants to draw salary, if he wants to draw remuneration, he will see to it that the default is correct. You got my point? He will see to it that the default. Because if the default is not corrected, he has to get the prior approval of that bank or PFI. It is shame, na? So he will be careful. He will see to it that there is no default to any of these people. So in a way, this is something that is good. They are not there in the earlier law. They are very good. Anyway, we already spoke about sitting fees. Sitting fees is fees paid for attending meetings of the board. Sitting fees means any fees paid to a director for attending meetings of the board or committee of the board, or for any other purpose decided by the board. This is called sitting fees. Fees, as decided by the board of directors, shall not exceed 1 lakh rupees per meeting of the board or committee. 1 lakh rupees. Okay. So up to 1 lakh per meeting. Believe me, some of the people who attend board meetings are big shots. They are consultants who can charge 1 lakh for 1 day or like that. They are big shots. So that's why they're given a ceiling limit of up to 1 lakhs or 10,000, 20,000, 25,000, whatever per director per meeting. You can pay. This is in addition to any reimbursement of travel, stay, etc. Okay. Now, so same sitting fees should be paid to the directors and women directors. See, for example, you cannot say sitting fees for Mr. X and Y and Z 50,000 per meeting. For others, including independent directors and women directors, 10,000. No. Everybody should get the same fee. If you want, you reduce that fee to this level. But the fee payable to independent directors and women directors shall not be less than the sitting fees payable to other directors. Okay. This is to protect independent directors and women directors. Because after all, even if they sit fee, one board meeting will be minimum 4 hours. They come in the morning, sit. Sometimes they'll have a lunch and proceed onwards till 4 p.m. It's almost a whole day's work here. So if he's a senior consultant or a professor from Harvard or whatever, fellow will charge much more than that. So 1 lakh is a very reasonable amount that they are proposing. But the only problem is, if you want to pay one guy, you have to pay everybody the same. Right. Where a company has no profits or its profits are inadequate, the company may pay to its directors, including any MD or whole-time director or any other non-director, including independent directors, by way of remuneration, any sum, excluded of any sitting fees, in accordance with the provisions of Schedule 5. So, up to now, we have seen where there is profit. Adequate profit. Now, inadequate profit. Means, you have fixed the salary for these guys, you total up the salaries, you see the limit, there is no profit, or the profit is not adequate to pay these guys. It is inadequate. In those cases, you have to go through Schedule 5. Now you will have to come to Schedule 5, Part 2, Section 2. Okay. The word non-executive director is used here. It is used in Schedule 5. Section 197 also uses it. I told you, proviso to Section 197 uses the words non-executive director. It's not defined. It shall be construed to mean a director who is neither MD nor WTD. That is what they are saying. A director who is neither MD nor WTD is a non-executive director. It includes independent directors also. So, in a year of loss, where the company has no profits or its profits are inadequate, you will move to Schedule 5, Part 2, Section 2. Okay, we already saw this, where in any financial year during the currency of tenure of a managerial person or other director, a company has no profits or its profits are inadequate, then it can pay remuneration to the managerial person or other director, not exceeding the limits given in this section under clause A and B. So we are going to see the limits where the profits are inadequate or losses. You know, the justification for this is very important. You are a chartered accountant. You are going to become a chartered accountant. You are employed with a company. Now the company is doing well. They pay you salary, etc. You are happy. 4 lakh salary, 5 lakh salary, 10 lakh salary per month. Excellent. Company is doing well. They pay you. You are great. You buy your BMW. You are enjoying your life 1 year. Second year also profit, no problem, continues. Third year, due to some business cycle, due to some recession in USA, your company is doing its best to make money. Still, because of overall global recession, the company loses money or makes less profits. Now, company is not able to pay the salary to you. You are not a director. You are only chartered accountant, CFO. You are getting what? 10 lakhs into 12, 1 crore 20 lakhs, 1.5 crores, enjoy. Now, they're coming and telling you, boss, this year we are not having profits, so we cannot pay your remuneration. Will you accept it? Will you accept it? So you are a chartered accountant, CFO, you are not willing to accept it. The MD of the company, he is running this company for the last 2 years, the last 10 years. He has made so much profit for this company. It so happens this year it is inadequate. Should he not be paid at least minimum salary? Is the question. The answer is yes, he is entitled. In just the last no remuneration, who will be MD of company? Professional managements will not come. See, especially if you are hiring out of IIMs or Harvard or ISB, come on, yeah, the guy won't come. If you put one condition that, you know what, in India we have Schedule 5. Now you understand why the comparison with other countries. When these experts come for employment, they don't come to India. They say, no way, man, I will not be CEO of your company. How can I be? Because you got the Schedule 5 nonsense, blah, blah. So you won't come. And remember, who is this guy? This guy studied in IIT Kharagpur. Okay? He was an all-round winner in school. CBSE was a topper. Then he goes on, school topper. Then he goes on to IIT Kharagpur. Nothing less. And he flying colors, he comes out. Goes on, okay, to do an IIM from Ahmedabad. Then he joins a large multinational company, goes on to become vice president, then becomes CEO of a startup company. Again, takes that company to big heights. Now you want him to become CEO of your company, MD of your company. Now, just go to this guy and talk to him about Schedule 5 and let's see if he's willing to even listen to what you're saying. So that is why they have given an option. They're saying, again, but then amount is, don't what the table links effective capital. I'm so sorry, my connection is unstable. I'm sure some of you will have a complaint. Let me wait. Yeah. So they are asking you to calculate effective capital. Based on the effective capital, they are saying you can pay him remuneration, yearly remuneration. Okay, got it? Yearly remuneration, not monthly. The figures that you see in column 2 and 3 are not monthly. They are yearly. Anyway, okay, I can convince, but for that your effective capital should be high. So, what is effective capital? In a short while, I will tell you. Right now, assume that there is something called effective capital. Effective capital in rupees is negative or less than 5 crores. Negative or less than 5 crores. What is negative effective working capital? You compute effective capital in accordance with the formula given, and the result should be less than 0. Not me, not my definition, given in this schedule. I'll go, when I come there, I'll show you. Because I don't know what is 0, less than 0, boss. I don't understand. I don't understand the meaning of the word negative. So they are very clearly telling you compute the effective capital according to the formula. The answer should be less than 0. That is negative. Okay, thank you for teaching me mathematics. They want to be abundantly clear what is negative. In other words, where the accumulated losses are huge, there's a huge accumulated losses, and the company's effective capital is negative. Then still, even if it is negative or less than 5 crores, you can pay the MD or the full-time directors, etc. Other than, non-executive directors, the whole-time directors, you can pay them 60 lakhs per person. This is not common for all. Each person will get 60. Got it? 60 lakhs per person, per annum. Means 5 lakhs per month. Okay, enjoy. That's live a poor life. Go on with your life. Reduce your expenses, etc. The guy I am, he was you and go. The interview in the business center, or take him out for a wine and finally you'll come to the point. The search consultant will be there, the very senior search. The search consultant, the person would have somehow got this guy. Very difficult. Why should this guy come for a meeting? You will be there, there will be HR, the CFO will be there, gentlemen, making understand, hey boss, they won't talk about this. And well, no, I think I can. Currently, I'm in Amsterdam. Maybe give me about 6 months, I'll come. No, 6 months not possible. Why don't you try 2 months? Okay, I will try. Finally, in the second glass of wine, they come to, what do you think? No, you see our company is making losses. Oh, okay. See, we got this negative effective capital, blah, blah. Fellow is not even listening to you. But suddenly you tell him the number. We can pay you 60 lakhs per annum. He'll simply keep the wine glass down, not even bother. He'll get up. Then you drag him down and say, hey, wait. Sit down. Luckily, our effective capital is 5 crores and above, but less than 100 crores. We got 80 crores effective capital. So we can pay you every year 84 lakhs. Fellow is literally getting angry. Boss, just calculate my salary, current salary in euro. He's getting in Netherlands, in Amsterdam. Just convert euro into INR. Just see what the number is. These guys don't know what to do. Then luckily they find that they have made a miscalculation in the effective capital. The effective capital is 100 crores and above, but less than 2 crores. How about 120 lakhs? They are asking. 120 lakhs. Okay. Then he converts 120 into euro. You do it. You find out the euro exchange rate and find out what is 120 lakhs in euro. 1.20 crores, mind you here. 1.20 crores in India. Convert it into euro and see what this guy is. He does a calculation. Then he makes one important non-financial metric, which is, I want to come back to India. Mera Bharat Mahan. I will sacrifice. I will let go. Anyway, I'm now 55 years old. I want to retire. I want to settle down. My children are all abroad. They are in US, Canada. I want to come back to my India. And this is a good opportunity. Let me try. I'll convince my wife somehow to come to India. Let me see. 1.2 is workable. But little more, thoda dusra hai na, good. Then, luckily, the CFO comes out with the number and says, hey, our effective capital is, then I can pay you 1.20 crores per annum. Plus, I can give you 0.01% of the effective capital in excess of 250 crores. So for the remaining 50 crores, I can give you 0.01 crore percent of that 50 crore as additional remuneration. Okay. So this is something that they have fixed. So this is, I am able to make you understand that this is serious. See, in India, unfortunately, we've got family-owned businesses where The family members are not qualified. Some of them don't work. They simply roam around and they also get paid. That is where the problem is. Whereas most European countries, UK, US, the directors are actually working directors. They work. They are like any other employee. They work and they are highly paid work. They are not son of MD. See, family-owned business in India, the son of the MD who is engineering college dropout, who has no qualification, he will be getting this money. That is when it becomes a problem. But if the guy is extremely, while I've said that, believe me, about 30% of Indian top family-owned businesses, second generationers are highly qualified. They are highly dedicated. They work like professional managers. Okay, they work day to day. I've known a lot of second generationers who work day to day. Think it's my father's company, sit at home and enjoy. No, they come to office. They don't throw their weight around. They understand the issues. They take proper decisions. They motivate their team. They make them perform. In which case they should be paid. Yeah, why should they not be paid? Merely because they belong to the family doesn't mean that they are not entitled to the remuneration. So there are two types of people are there. The second generation which thinks father's money, I can blow it. And the second generation which honestly knows this is my father's business, but still it is a professionally managed company. I cannot rely on my father's support. I have to work now and prove myself and come up. This is the European model. This is the Japanese model. This is, all over the world. Only in India, unqualified fellows can come and sit merely because they are son of so-and-so. This is the problem. Okay, but for that, I think that is why what they said for appointment of MD and WTD and all, there should be a nomination. Understand? That's what they are. Okay. So, let's come. Let me see what it is. How can we define whether companies make adequate profits? Simple, sir. You fix the salary for them now. You have fixed some salary for them now. Total of all the salary. That number, if it's calculate that number, then you calculate these percentages on the profit. Compare. If the number you have selected is less than the percentage, adequate. Got it? If the number you are going to pay them, the salary negotiated with them, that total is more than this percentage, inadequate. Not adequate to pay the salary. It is, profit is there, but not adequate to pay the salary. Year of loss, no problem. Negative. Company has made adequate. You understood, Ms. Gayatri? And since you are now able to ask questions, God is great. Okay, mashallah, you are able to hear what I'm saying. Thank you. Did you hear what I said just now? Have you understood? Okay, good. So, capital. Now, I have defined effective capital for whole-time directors, MD, etc. Other than, other director. Do you remember what I said? Other director means director who is neither managing director nor whole-time director. Okay. For them, the amount is less. But even they are entitled to some amount in a year of loss or inadequate profit. After all, hey, these guys are also contributing, right? So they are also entitled. You can pay them 12, 17, 24. Then 250 crores and above, you pay them 24 lakhs per annum for 0.01% of the effective capital in excess of 250 crores. Try to remember this chart. It's not very difficult, right? It's not very difficult. It's if you are good at 6 tables, it is enough. Am I correct? 6 tens, correct? And 84, 60, 84, 7 lakhs. So 60, 5 lakhs, 80, 120 lakhs, 10 lakhs per month. So here it is simple, 12, 17. I don't know where they got that 17 lakhs from. Very odd number. Then 24 lakhs. Okay. So the remuneration in excess of the above limits may be paid if the resolution passed by the shareholders is a special resolution. So understand, Schedule 5, he should be eligible under Schedule 5, conditions should be satisfied. Appoint him. Profit. I am kind enough to accept plus point. Companies 300 crore. Your boss 1.01% beyond, take it. No, not than 2.4 crores. 230 lakh. That's what he says, boss. Don't even talk in your dirty rupees terms. Talk to me in euro. This is my euro salary there. Okay, whatever is the euro salary there. I don't even ask for a raise. Whatever I'm getting in euro in Amsterdam, pay me here in India in INR. I will even handle the exchange risk. He is willing. That is the sacrifice I'm doing for you. On negotiation, this is my sacrifice. Because my wife is sitting in Amsterdam, she is not going to come back. I have to send all the money back. Definitely, I'm going to lose on exchange. Chalo, I'll accept that. But whatever I'm getting in euro, you pay me here in INR. So convert it. If he is smart, what he will say, peg it on euro. If the euro rises, salary should rise. I'm not joking. That is how the negotiation happens. That is how it should happen. Because, see, the guy is getting in euro, boss. Why should he lose? Because he's coming to your country. Because it's rupees. So if he says neutral euro, pay me, if possible, pay me in euro. Okay, if you want to pay him in euro, different law. I'm not going there. Maybe when we go discuss. Right now, whether you can pay him. So finally, what do you do? The CFO, the VP HR, and the consultant, they will tell, boss, one more super wine we have ordered. Just try it. It's a Sauvignon white, fantastic blanc wine. Just try it, boss. I get him some chicken, tandoori chicken. Yeah, let this guy be eating. Just come in 2 minutes. They both will go out to the reception area or some alcove in the hotel. They both will discuss what to do. Luckily, you have studied company law. You are the CFO and you are taught company law. And I taught you Schedule 5. So you will remember, boss, we can't get a better CEO than this. We have been told to hire him. We will hire him. I will go to the central government and we will go to the shareholders and get the special resolution passed. Oh, that's all. You have to pass this. It's okay. We will go through it. I will take care. If possible, have the company secretary also with you. But then don't take the company secretary for this meeting. It is too important. Later on, next day when you go back to office, you call him, Mr. Company Secretary, this is how it is. Oh, he'll see the number go faint because he will not be getting that much. Faint, stand up. Then put water on his face, tell him, boss, call for a GM, general meeting, pass a special, get a special resolution. Okay. If a special resolution is passed, no problem. But if the special resolution is not passed, I have to go to central government for approval because exceeding the limits subject to the provisions of Schedule 5. See how 197 and Schedule 5 are interlinked provisions. Unless you appreciate the interlinking, don't study them alag-alag. You'll go mad. But study them together, easy to link. What to do? Okay. If you want to exceed these limits, go to central government, file at the approval. But shareholders do not approve, you are out. Given the power to the shareholders. If you want to exceed double limits, if your shareholders are okay, please go ahead. Okay. Now, somebody may ask a question. Sir, I'm appointing him for 9 months, sir. Then how to pay him, sir? You can't pay him 120 for 9 months. You have to pay him 120 by 12 into 9. Obviously, now, whatever remuneration mentioned there will be prorated for the period of office. If it's half a year, then half. Whatever. Divide by 12, multiply. Divide by 365, multiply. Your choice. Prorate it. If it is less than 1 year, the limits shall be prorated. Okay. Now we come to effective capital. Okay. What I'm going to do is, today I'm going to take you through this, but this can be better appreciated only if you work out a few problems, meaning number crunching types. Not very difficult. Believe me, for a person, first of all, I'm going to tell you something. You guys have completed intermediate of CA. I'm not joking. I mean, this is possibly you may hear, then intermediate of CA is superior to even some professional qualifications. I won't say which. Inter CA is more intelligent than certain professional, fully qualified, final pass of certain other professions. Don't ask me which. Because you guys are cramming so much. Yeah. In intermediate level itself, you are studying so much. And for you, number crunching is nothing. Some problem which is seen as very tough problem by some other professional course student, for you it is nothing. Still understand vision better. Good if we can work out some number crunching problems. Hopefully, inshallah, I will do it in the third session when I will take you through it. Right now, I'm only going to teach you the theoretical part, which is effective capital, how to compute it. So, if possible, make a note of this. My system itself is saying your internet connection is unstable. I can understand how difficult it must be for you, which is why, sometimes I say, see, being a practicing Hindu, okay, I believe in my religion and I believe in the polytheistic nature of my religion. Even though I'm an enlightened monotheist, I believe in a single God, Vishnu. Still, I'm able to accommodate all the other gods in my pantheon into my belief system. I have no problem in doing that, which means that I can understand a god like, say, Indra for rain, and a god like Agni for fire, or a god like Varuna for water and the seas, and so on and so forth. We have a god for everything. Okay, we have 33,000 crore gods. Okay, and so we have enough and more for everything. Why can't we create one more god for? In fact, we've even got a god of small things. Why can't we have a god for the internet? What do you think? I even got a god for the internet. Just like, before we do something, we make a prayer to specific gods, Agni or Varuna or whatever we want, we pray. So sometimes I think we should have a mantra for the god of internet. Just like, for lightning, we have Vidyut. Vidyut is the god of lightning. Okay, like that. Maybe that Vidyut, who is the god of lightning and electricity, should also become the god for, internet connections. So before we switch on the internet for online classes, we should chant that mantra and then start the class. In fact, I even started thinking like that. Before I start, I should sit and pray. And Lord, whatever happens today, please let the internet connection be stable. Even if I am not able to satisfy the student in terms of making them understand due to my inability and my foolishness, at least let the internet be stable. Like that, there should be some mantra, okay, which you should chant, Om Shanti, Shanti, Shanti. Then we should proceed with our class. I'm just joking, not joking. My religion is too serious for me to joke, but my religion is big enough to accommodate such prayers. Okay, I can pray to such a God. And from next time onwards, I'm going to pray. Internet connection should be stable. In fact, next class, I will begin with a prayer and I will explain the meaning of that prayer to you. Okay? Because even if you do not believe in God, or if you believe in some other God, which is absurd, all of us believe in the same God. So whatever God you believe in, boss, prayer is a power. Prayer is a power. Those who pray are powerful. They are not weak. They operate from power. Okay? Those who are egoistic are weak. Whereas those who pray are powerful because they want access to something bigger than themselves, which can take them to unsolicited thing. But I hope little bit for a guru, a certain degree of sharing these type of thoughts is permitted. Also, I am giving you some time to absorb what all I have told up to now, all these things. Okay, because in the exam, they might ask you a question which will not be theory. No way they're going to ask you to write this table there. But this table should be in your mind. It should be in your mind. Okay, this should be in your mind, this should be in your mind, and this table should be in your mind. Means you should be able to create it. So spend a little time when you're going to office or when you're sitting at home, then you just put this on your mobile. You just take a photograph of this and put it on your mobile as a picture. Go through it. That's all. Suddenly you will find you're able to remember it. Memory works. This is also a photograph. Put it on your mobile. Keep it with you. If not, when I'm sending the PDF part, you just cut that part and as a JPEG and keep it. Keep it in your mobile so that whenever you are free, sitting in the train, not knowing what to do, instead of going to the Instagram, instead of going to the, all that YouTube and all that, or simply blindly following somebody on Facebook, simply read this. Automatically, you will remember it. Okay. So effective capital definition is a computational definition. Include, exclude, reduce. So ideally, what they will do in the exam is give you extract from the balance sheet. Typical problem in the exam would be an extract from the balance sheet or an entire balance sheet itself. Ideally, they won't waste your space of the paper giving the entire balance sheet, because all they need to give you is only liability side, shareholders funds. That's all. Nothing else is needed. Reserves and surplus, share capital, reserves and surplus, extract. Now, what is to be included, what is to be excluded, you should know. Include paid up share capital. Be careful. Paid up share capital includes paid up preference share capital also. Make a note of this somewhere. Because in the exam hall, you will forget it. Here you will all nod. I know, yaar, is wasting my time. All nonsense, like he's talking God, Vidyut, Manangati, all that is useless fellow. Agreed, I am useless. But remember, in the exam hall, you are in a different tension. So I'm repeating, paid up share capital includes preference share capital also. It includes securities premium account. But though we call it securities premium account, here they call it share premium account. Why? God only knows. Because everywhere else it is security premium account. Here alone it is called share premium account. Kyun? Mujhe nahi malum. I don't know. Ask whoever drafted this. Okay. But I think what they mean is security premium account only. But for fun, they call it share premium account. Reserves and surplus. All complete. Okay. No, we will see. Certain items should not be taken. Other than that, everything can be taken. I will tell you. Debenture redemption reserve is there. TRR. Debenture redemption reserve can be considered. To the next chapter, 181 paid up capital and free reserves. The word free reserve is defined in which are available. Here they don't say free reserve, they say reserve and surplus. So reserve and surplus can be taken except the specific exclusions. So equity share capital taken, paid up share capital taken, securities premium account taken, reserves and surplus being considered. Long-term loans and deposits, repayable after 1 year. That also should be given. Sorry, the non-current liability should be given. Both non-current loans and deposits should be given, will be given to be added. See, what you're getting is capital boss. You remember, for accounting ratios, you calculate return on capital employed. What is the total capital employed in this business? Why this is given as a measure of his ratio? If the amount is high, the type of decisions he is going to take is complex. If this amount is low, the decision making is also going to be less complex. Please understand. At that level of management, it is not how much time he is spending like that. No. He has to take complex decisions. He has to decide what to do. Powerful. So more the capital he is employed, which is employed in that business, more complex his decision making need and his strategic abilities. Therefore, they say higher the effective capital, more the remuneration. So, which is why for capital, we should not take only equity. Owners, you should also take the debt. So they are saying, and again, they're saying don't take the current debt, the working capital and all that. Take only the long-term loans and deposits repayable after 1 year. And included. CC is a demand deposit. Sorry, demand loans not to be included. CC is a demand loan. It is repayable on demand. So only those loans and deposits which are repayable after 1 year should be considered. Right? Now, while you are including all this, please remember to exclude these fellows. A, share application money pending allotment. It is there because that money is, it may not be allotted, in which case you have to include it. you allot the share on the, okay, before the year ending, you allot share as on the balance sheet date, there should be application pending allotment. If on the balance sheet date, that's to be excluded. Both under shareholders' funds. Reserve. It's a notion, not even waste about it. You are intermediate, maybe even fine. Way you know whatever it is notional, it is not profit, it is not in cash. No way I can consider. Okay, and the account, so it will go away once the depreciation is fully charged. The revaluation reserve will go out of my balance sheet, right? Working capital loan, I told you, CC, overdraft, take it out. Interest due on loans unless funded. Okay, interest due. That is, you can take the loan amount, but you cannot the interest due unless the interest itself is being funded. Recently we had the pandemic situation when during the pandemic period, they said you need not pay the interest, and then they allowed you to pay that interest in installments. And then the banks tried one more stunt. They tried to charge interest on that interest. Then they went to Supreme Court, and Supreme Court said, no, if you waived the interest payment for some time, no problem. If you are permitting him to pay it in installment, no problem. But on that interest, you cannot charge interest. So that has been recredited back to the accounts. But whatever it is, if the interest is funded, take it. But if it is not funded, cannot consider outstanding interest. Obviously, bank guarantee cannot be considered because it is not even in the balance sheet part. It is only it's a contingent liability which will be mentioned in the notes on accounts. Of course, you cannot expect the ministry people to understand accounting to that level. And other short-term arrangements. Okay. Investments. Be careful. Investments is on the asset side. Now, to the extent of investments made by this company, that money is not being used in this business. Friends, understand why investments is excluded. But again, by excluded, I think what these funny creatures mean is it will be reduced from the number. You understand? Because exclude means it must already be there, only then I can exclude. But investments is going to come on the asset side. So what they mean is, you total up paid up share capital, share securities premium account, reserves and surplus other than these fellows, long-term loans and deposits, repayable after 1 year, other than working capital loan, etc. And from that number, you reduce investment also. You see the asset side, any investments are there, remove it. Both non-current and current. Because that money is not in your business now. Suppose this company has invested 80% of its capital in another company. Then why should I pay him here? Because the effective capital is fully invested there. And this guy is not managing that company. Therefore, I should not pay. I will remove investments is the point. Right? Now, accumulated losses and preliminary expenses. If they are there. But remember, in the reserves and surplus, this will be coming as the negative item. That should also be reduced. Right? Now, in the year of incorporation, effective capital shall be taken as on date as on the of the financial year preceding financial year appointment of the managerial person is made. Which means if you are proposed to appoint this guy in November 2022, you will have to see the audited financial statements or financial the balance sheet or the financial statement as on the last date of the immediately preceding financial 3/2022. Okay, should be considered. Okay, got it? That is what I'm saying. As on 31/3/22, if you are having share application money, subsequently it is allotted, I cannot help you. On 31/3, it should have been allotted. Then it will be included for the purpose of paid up capital anyway. Otherwise, not to be considered excluded. Okay, fantastic. I think effective capital we have. It's a good point in time to, stop. I have a bigger question which arose suddenly. See, we are seeing the effective capital based on balance sheet of that company. See, we said investment should not be considered. But remember, the subsidiary companies are also managed by this guy only as MD, this team. So why can I not take the net worth of those companies? I mean, just loud thinking. So no, the law is enough for After all, my investment in those subsidiaries is represented by capital there and all that. So why can I not take that? It's a bigger question, but as of now, they have not even contemplated that. Okay, here's a question from Ms. Gayatri, very active. Today's player, what's that? Player of the match award, like that. Active participant of the day award goes to Ms. Gayatri. Active participant asking maximum number of questions. Usually Darasha will win. Earlier Vanacharla was winning. Today's winner is Ms. K. Gayatri. She has one more question to ask us. Sir, whether capital reserve is also included in effective capital? Yes, it is included because it is not specifically excluded. I have answered your question. It is included because it is not specifically excluded. Got it? Only these guys are accumulation reserve excluded. Capital reserve can be considered. Good question. Capital redemption reserve can be debenture redemption reserve can be included. Very good question. Very good. I have given my answer. Okay. So CRR can also be considered because here they have not used the free reserve. Free reserve means you'll be in trouble because free reserve means reserves which are available for declaration of dividend. So here they have not used the word free reserves. Therefore, even debenture redemption reserve can be considered. Capital reserve can be considered. Capital redemption reserve can be considered. Everything can be included in effective capital. See, they are trying to find out the permanent capital of the company. The amount which is used in this company for running it. That is the goal here. Therefore, they permit you to do it. They are not trying to calculate any limit or etc. Fantastic. We have reached a fantastic point where it is better for me to close as of now and look forward to interacting with you on a day which will be announced by the institute. Okay, because Friday I might be having some other commitments. So actually, I'm traveling now. I'm in a city called Coimbatore. I have a small residence here, and I keep coming here and going. So this week I'm in Coimbatore, but I'll be moving again to Kodaikanal, Dindigul, then Kodaikanal. Then again I'll be back in Chennai. So I keep traveling a lot. I'm a Banjara, a gypsy. I keep traveling a lot, and I spend a lot of my life in hotel rooms and out of suitcases. But I love that. I like to keep on changing my location, and that's the way I like to live my life. So nice talking to all of you. I hope today's lecture was useful to you. I hope you have understood the topic relating to, managerial remuneration up to this point. If you like the lecture, just give a thumbs up or just give a word of whatever on the query pad before you go. Thank you. Bye. Good night. See you again. Bye.